Delivery of judgment. Item number 52, WPC 2847 of 2019.
This petition dismiss.
Item number 53, WPC 4225 of 2019.
Petition allowed.
Item numbers 54 to 58, WPC 379 2020 and 4 others.
All the petitions dismissed.
Item number 59, RSA 170 of 2024.
RSA dismiss. Yes.
May allow to withdraw this petition.
Ms. P. Coletta, learned counsel for the accused, submits that she has the instruction to withdraw this petition. Accordingly, this BA is thus disposed of on withdrawal.
Obliged.
Or motion be, item 1,
May I please, Your Lordship? Your Lordship, the charge sheeted matter and the POXO is there.
Okay, notice.
Yes, notice and
Scan copy of the record.
yes, sir.
Don't mind. Notice to the office of the PP, Gauhati High Court, and SSL call for the scan copy of the TCR from the learned trial court.
Session court, Sri Bhumi.
Session court. Yes.
on 18 August.
Obliged.
Item 2,
Lord, this is 483 BNS application. He is in custody since 29/5/26. That is 73 days.
70?
73 days.
73 days.
This is related to cyber police case. 7. Huh? 43 days, 73,
29/5.
29/5.
29/5.
Then, my lord, I will have to.
He arrested at 29/5/226, 6, 7, 8. As per my calculation.
All these are 60 days offense.
Yes, almost 60 days is over.
well, after some time.
Okay, after some time.
Item 3,
Wait, please, Your Lordship. It's an NDPS case, my lord. Case diary may be called for.
CD on. Borthakur.
Start of session will be too long, my lord. 19 period.
item 4,
I'm deeply obliged.
May I please, Your Lordship? Lordship, the matter has remained part, Lordship.
Okay.
Lordship, I'd like to say, Lordship, before making my submission, Lordship, I want to make an additional affidavit by reflecting the relevant question, Lordship. I want to submit the additional affidavit by reflecting the relevant question, which are essential to the just decision of the case, Lordship. Kindly give an opportunity to submit the additional affidavit.
When the next date is fixed before the trial court?
Lordship, it was fixed for. Lordship, may I be permitted? I brought the diary. May I take the diary? 25/9, 25 September.
And oh, at which stage the case is pending there?
Cross-examination of PWs.
PW.
PWs. One PWs was examined. Complainant case.
Heard Mr. Zaman, learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. Mr. Zaman submits that he may be allowed to file an additional affidavit in this matter, and he prays for granting him some time. They are allowed. Raises at least the matter is started on next Monday.
17.
Yes.
Item 6.
Please. Okay, this is a revision petition, Lordship. Against the judgment and order dated 21/01/2026, passed by the learned session judge Gauhati in criminal appeal number 03/2021, and the appellate court dismissed the appeal in devoid of merit, Lordship. So this case is, Lordship,
Heard Mr. Your name, please.
or Lordship.
Learned counsel for the petitioner. This petition under section 438, reduced section 442 of the BNSS 2023 is directed against the judgment and order dated 21st of January 2026, passed by the learned session judge Gulagat in criminal appeal number 03 of 2021, whereby the learned appellate court has upheld the judgment and order dated 21st of upheld the judgment and order of the learned Chief Judicial Magistrate Gulaghat in CR, which is NI case number 47 of 2019 under section 138 of the NI Act. It is to be noted here that by the impugn order dated uh 7/12, impugn judgment and order dated 7/12/2020, the learned Chief Judicial Magistrate Gulaghat has convicted the petitioner herein under section 138 of the NI Act and sentence him to payment of fine only, amounting rupees 3 lakhs. 3 lakhs with a default stipulation. Default stipulation. Peruse the petition and the documents placed on record, and also peruse the impugned judgment and order dated 21/1/2026, passed by the learned appellate court, and also the judgment and order dated 7/12/2020, passed by the learned trial court. Issue notice to the respondents, returnable in 4 weeks, the be taken by speed post and also by usual process within a week from today. Shall call for the records from the learned courts below. List the matter after 4 weeks. And pending disposal of this appeal, the sentence so handed down by the learned trial court and affirmed by the learned first appellate court stands suspended till disposal of this appeal and the disposal of this petition. Until then, the petitioner shall remain on previous bail.
Item 7.
Obliged.
May I please? As per the Last order, your lordship, I have annexed the lower court's judgment as annexed two. That was not annexed earlier.
You have not filed the affidavit.
I have filed the affidavit. Filed the affidavit.
When?
I have filed the affidavit
When?
because the annexer two was not annexed earlier. That was the trial court judgment here.
No, that's all right. When did you file the additional affidavit?
On last question, I think 4 days back.
4 days back, but it is not placed on record. Heard Mr. Burman, learned counsel for the petitioner, Mr. Lawfer, learned additional PP for the state respondent. Mr. Burman submits that he has filed the additional affidavit bringing on record the judgment of the learned trial court in NI case number 06 of 2020. But office note dated 6/8/2026 indicates that no additional affidavit on behalf of the petitioner has been filed till that day.
Lordship,
Shall list the matter on
tomorrow, day after tomorrow. Because
Wednesday.
Got
Taking the affidavit filed by the petitioner with this record.
Number 8.
May I please? May I please? We have filed it for challenging the order taking cognizance, madam. That order, my lord, will find at page 35. Order taking cognizance.
Page number
Page number 35, madam.
35. What is the ground for challenge?
Yes, madam, I'm coming to that, madam. Here, my lord will find that the cognizance has been taken under IPC along with section. It is written 52, it should have been 25, madam, 25 1A
Yes.
of the Arms Act. Now, my lord, if to take cognizance under 25 1A, there has to be a sanction from the district magistrate. My lord, with regard to that, may I place a judgment, my lord, of this High Court, my lord? Paragraph 9, madam. Paragraph 9. Paragraph 9, madam.
Yes. Arms Act. You have filed this petition under section?
For causing, madam.
Causing.
Under section 28, madam, 482 of CRPC, madam.
But you see, your alternative remedy is available before the session court.
Madam?
You can file a petition for discharge there.
No,
Then,
charges not framed, madam. This is order.
Maybe before framing charge, you can file an application there for discharging you under the said section. See, this is a extraordinary remedy.
Madam.
So when your remedy is available before the trial court, you cannot maintain this petition.
But my lord, thing is that say,
it says, my lord, there is no doubt that sanction for prosecution is a
No, that's all
precondition,
right. Yeah.
precondition for initiation of a proceeding under 25(1)(a) of the.
There is
is a precondition.
undoubtedly merit in your submission.
My lord,
But what I am saying is your remedy is available there. You can file an application for discharge.
but this is totally abuse of the process, my lord. Abuse of process. My
Pardon?
lord. Abuse of the process, my lord.
Okay, but
And-
we have
and-
to see under what circumstances we can exercise the extraordinary remedy. You see the judgment of the Niharika infrastructure? And tell me, can we exercise this power
Okay, my lord, let it be on Friday, my lord.
on
Friday, if possible,
Friday?
my lord.
Okay, on the pair being made by Mr. Munir, learned counsel for the petitioner, this matter is then adjourned to be listed on Friday for hearing on the point of maintainability of the petition in view of existence of alternative remedy before the learned session court, before the learned courts below.
14. Deeply obliged. My lord, if I may take one opportunity, my lord, I'm not feeling well, my lord. I have one more item, my lord. Item 50. It's for condemnation of delay, only notice is required to be issued.
50.
50.
Okay. Heard Mr. Munir, learned counsel for the applicant. This application under section 5 of the Limitation Act is prepared by the applicant for condonation of delay of 151 days in preferring connected criminal revision against the judgment and order dated 8/12/2025 passed by the learned judicial magistrate first class Lakhimpur, North Lakhimpur in Miss case number 19 of 2023. Peruse the application and the documents enclosed therewith. Let notice be issued to the respondent returnable in opposite party returnable in 4 weeks. The bid taken by speed post and also by usual process within a week from today, list after 4 weeks.
I'm deeply obliged.
Hi.
Wait, please. It's your this last occasion, this honorable court directed the PT to list the instructions whether the SOP which has been issued, is there any cross cases?
Yes.
My lord, in this regard, I would like to point out, Madam, I have come to the portal notification to see the notification for which of the cases, some of the cases which are, that is there in the, there are some that SOP was different. But only, my lord, that one notification which is, my lord, was condition that he see, my lord, will be at liberty to file complaints on that. If my lord also spend that in any case, if any of the victim is agree with the proposed withdrawal,
Mm.
he will be at liberty to file complaint case on their own. Earlier that, my lord, the provision was not there. Now, my lord, now his submission is that both cases are cross cases. But my lord, I would like to point out with your lordship, he has annexed in the petition, my lord, only one case, one affair of the case. My lord. Regarding the POSCO Act, well, he has not annexed that affair. So from only after going through both the affairs, my lord, otherwise from the content itself reflects that both cases are not on the same text, my lord, and circumstances. One is, my lord, registered under POSCO, my lord. That is, and one case is registered on the same date, my lord.
Mm.
One case was registered by one informant, Anima Begum, my lord, against there before that, my lord, one case which was registered as, my lord, Romia PS case number, my lord, 156, my lord, before the case, my lord, of the present petitioner, my lord, that is 156/27. That is, my lord, against the, my lord, that informant of the husband of the informant of the, my lord, the case filed by the present petitioner, my lord. So, my lord, from the, my lord, the prima facie, it seems that both cases are not, my lord,
No, now both the affairs are not available on the record.
only case of the FIR of the present case.
I will place the record. I will place the
And
FIR.
regarding, I would like to point out one, my lord, order of the trial court, my lord, from the petition itself, my lord.
Mm.
Accused in the, after, my lord, case was withdrawn on 6/6/2022. my lord, allowing withdrawal of the case by prosecution in view of the notification that is in the year 2023. Thereafter, my lord, notification, my lord, modified notification is dated 29/2024. Now, my lord, page 43, my lord, on 3/5/25, the present accused person in POSCO case filed a petition before the special judge, my lord, Kamrup Romia, for clubbing together both the cases. So, that is in page 43. That we come to page 43. Thereafter, my lord, the learned trial court, my lord, page 46, my lord. Your lordship may kindly. Accused is present, all for the case record is received from the learned FDCM Romia. So, my lord, case record was called for and case record received, my lord. The same is kept with the CR, issue summons to PPW. So thereafter, my lord, regarding no order passed regarding clubbing of those, my lord, cases, already one case already, my lord, withdrawn on my lord 6/6/23. And now on the basis of his application filed by the before the, my lord, special court, my lord, the special court has called for the record. And now the record is, my lord, before the special court. Till now, my lord, what happened to thereafter, my lord, my lord, now.
Because the learned trial court has known the gravity of the offense, because by misusing the entire fact, this,
No,
this.
Mr. Borua, you do one thing. You bring on record that FIR, we'll see.
I will.
No.
Lordship, then I will file.
Not in that way, you bring it on record by filing additional affidavit.
Lordship.
Heard Mr. Borua, learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur, during the course of hearing, pointed it out that the petitioner herein has not enclosed the FIR of the POCSO case.
150, that is 156/2018.
POCSO case number 150 of POCSO
Romia
case number what?
POSCO case number 10.
POCSO case number 10 of 2018. 18. Mr. Borua submits that he may be allowed to bring on record the said FIR by filing an additional affidavit. Fair allowed, lays the matter on next Tuesday.
Lordship. What did you?
Item 14.
Let me. In this case, Lordship, I'm challenging the order whereby NBW was issued. Lordship, may kindly see page 53, this order.
Where is the impugn order?
The impugn order is at page 54. Lordship, may
54.
kindly see 53 first, Lordship.
Page number
53.
53.
Because this matter relates to ATA Act, Lordship, he already submitted before the trial court that he is willing to settle the dispute and he will pay the money, Lordship. That reflects in page 53. Only 15 days time was granted.
No,
to him,
no,
Lordship.
where is the impugn order?
Page 54. As he failed to pay within that 15 days time, Lordship, therefore that NBW was issued. And in fact, in this petition also, I have specifically mentioned that he is ready and willing to pay, Lordship. So NBW may be required and some time may be granted to him to repay, Lordship.
No. If you are playing the game of hide and seek, why the trial court should not issue non-bailable warrant of arrest against you?
Therefore, I have referred to page 53. Lordship, may kindly see page 53.
That itself is not a ground for excusing your absence in the court.
No, Lordship, he has submitted before the trial court in the month of April.
Mm.
And on April, Lordship, he was granted only 15 days time. And he was suffering for some ailment, which is reflected in the order also. Otherwise, he will pay, Lordship.
That cannot be the ground.
Because on that day, Lordship, when impure order was passed, he has also submitted some medical prescriptions also. Because of
Where is that document?
that document I have not enclosed, but it is reflected in
You
page
bring
54
it on the
itself.
record. We will see. We will examine what is the ground.
Or may I pray, Lordship, that Lordship may dispose it of by directing to pay 20% and
No. We will only examine the impugn order here. Heard, Mr. Ahmed, learned counsel for the petitioner. And also heard Mr. Borthakur, learned additional PP for the state respondent. Order dated 15/5/2025. Passed by the learned subdivisional judicial magistrate M. Bilasipara in CR NI case number 427 of 2022. Is challenged in this petition. Under section 528 of the BNSS 2023, read with section 442 of the BNSS 2023. It is to be noted here that by the impugned order dated so and so, the learned trial court has issued non-bailable warrant of arrest against the petitioner as he defaulted in appearing before the learned trial court on 15/5/2026. The learned counsel for the petitioner submits that on account of illness, the petitioner could not appear before the learned trial court on 15/5/2026. And he has also filed an application enclosing some of the medical documents. But the said petition and the medical documents are not part of the record. Mr. Ahmed submits that he may be granted some time to bring on record the application and also the medical documents. Parallel, list the matter on next Tuesday.
Till then, he is serving as a teacher, also, otherwise he will lose his job. Also. Obliged.
May please, your lordship. My lord, here in this case, my lord, we have there has been a FIR against the petitioner stating earlier that he has submitted false documents in Panchayat nomination paper and he was got elected. After being defeated, the private, my lord, the rival candidate has filed the FIR as well as filed a petition before the criminal election petition before the tribunal, my lord. So, my lord, the charge sheet, my lord, indicates is submitted in this case, and the whole allegation is false, my lord. And I have obtained some my lord, certificate from All India Education Parishad, New Delhi. My lord, against that institution, there has been some observation by Delhi High Court and Supreme Court on approach by the said Parishad before the Supreme Court. Supreme Court has made observation, lordship will find at page 33, annexure 9. So, my lord, there has been some ill reputation, some news against the Parishad, my lord, but Supreme Court has said that those observations are not correct. So, my lord, I have been duly elected, participated in the election. After being defeated, filed election petition as well as, my lord, in the FIR, my lord.
No, is
So,
there any bar in filing
there is
election
no
petition
bar.
and also
No bar.
filing
That
criminal
can be.
complaint?
The whole allegation is there, if my lord is false, my lord. Lordship may call for the records, and if our claim is genuine, my lord, then the proceeding, my lord, criminal proceeding may be stopped.
Submitted.
Heard Mr. Sigdar, learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the state respondent in this petition under section 528 of the BNSS 2023, read with section 442, 438, 482 of not 482. 438 BNSS 2023. The petitioner has prayed for quashing the proceeding. Quashing the charge sheet number 79 of 2025, dated 12/4/2025, arising out of Dhing PS case number 95 of 2025 under section 336, within bracket 2, stroke 340, within bracket 2, BNS. Peruse the petition and the documents placed on record. Let notice be issued to the respondents returnable in 4 weeks, that be taken by speed post and also by usual process upon respondent number 2 within a week from today. However, no verbal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. Pervix the requisite copy of the petition be furnished to him during the course of the day. Registrar shall call for the record from the learned trial court. List the matter after 4 weeks. Interim care of the petitioner will be considered after receiving the record from the learned trial court.
My lord, the next date is on 13/8/2026.
13.
8/2026.
But before that, you will not be able to serve notice upon respondent number 2.
My lord.
So you file an application there. Today we are not staying the
My lord.
proceeding.
16.
My lord, Robson make an observation in the event of appearing before the court and filing a bail application that may be considered.
No such observation. Next item.
Item 16.
Developed.
My lord, I have filed this application, my lord, for quashing the NBW, my lord. I am now ready to appear and surrender before the trial court, my lord, because I did not receive the summon, my lord. I have categorically stated, my lord, I am
Where is the impugned order?
my lord, impugned order. My lord, type copy from page 40.
The delivery.
My lord, type copy 41, then 42. WA issued against accused Jamaluddin and Hanif Ali without execution and report. Page 42. I am ready, my lord, at any moment, my lord, at any condition.
No, by which order first non-violable warrant of arrest was issued against you?
My lord, order dated 4/12/2025, page 41. Then page 42 also, 5/1/2026. First one was 4/11/2025. The second and third order, there is a reflection that without execution with report, 4/12, page 41. Then page 42 also, without execution with report.
My lord, that with execution, report your summons properly served on the accused.
Page 40.
Page 50.
Case 52, my lord. But accused against summons issued to accused.
Yes, my lord. Court.
Execution with report that summons properly served.
My paragraph 5, in fact, the summon was received by another person, not by the petitioner. And thereafter, 2 more summons were issued that was not executed.
Who received the summon?
I have no idea, my lord.
You have no
I
idea.
have not received the summon, my lord. It is my paragraph 5 and paragraph 9, my lord. Paragraph 5. 6 also, my lord. He has no knowledge.
Sharma, you see, the trial court
Yes,
in the order dated 4/11/2025
yes, ma'am.
has observed that summon properly served upon accused Hanif Ali.
Yes. Then by the subsequent 2 orders, my lord, thereafter 2 orders.
No, maybe. This is the first order by which a non-violable warrant of arrest was issued against you.
Yes,
So your contention is that you have not received the summon.
yes.
Okay, then we will examine the record. We'll
Page
see
40,
on
my
what
lord.
basis the trial court has made aforesaid observation.
My lord, page 41, my lord,
Huh?
there is an observation there. Hanif Ali are returned without execution. Page
No, we are
41.
not concerned with that.
Yes.
We are concerned with the order dated 4/11/2025.
Yes, then paragraph 5, in fact, the summon was received by another person, not by the petitioner. Because I am a daily wage earner, my lord. I am moving here and there, my lord, with my family.
We'll see that. Heard Mr. Sharma, learned counsel for the petitioner. And Mr. Borthakur, learned additional PP for the state respondent. In this petition under Section 528, reduced section 482 of the BNSS 2023. The petitioner has challenged the order dated 4/11/2025 and 4/12/2025 and all subsequent orders passed by the learned subdivisional judicial magistrate North Salmora, Waipur in PRC case number 806 of 2023. No, 2022, arising out of Master PS case number 91 of 2016 under section 376 D IPC reduced section 5 of the Immoral Traffic Act 1956, whereby the learned court has issued non-bailable warrant of arrest against the petitioner. Mr. Sharma, learned counsel for the petitioner, submits that though the learned court has made an observation in the order dated 4/11/2025 that petitioner Hanif Ali has not received the summon. No, made an observation that summon issued to accuse Hanif Ali returned with execution with the report that summon properly served upon the accused Hanif Ali. However, he is not turned up. And according to Mr. Sharma, the petitioner herein has not received the summon. In view of the submission of Mr. Sharma, learned counsel for the petitioner, perusal of the record of the learned trial court is found to be necessary. And accordingly, it is provided that Registrar shall call for the scanned copy of the record from the learned from the Court of Learned SDJM North Salmora, Abhayapuri, fixing the matter on Thursday.
Section 17.
Resolution. So this is a 528 application, my lord. For quashing of a proceeding under the DV Act, my lord, we are the in-laws, my lord. Petitioner number 1 and 2 are the brother-in-law, my lord. 3 and 4 are the married sister-in-law who do not live in the shared household, my lord. And petitioner number 5 is the father-in-law. If your lordship will kindly come to the
Is it the requirement that they have to share the same household?
under the DV Act, my lord, for domestic violence, and the requirement of sharing a household is there, my lord. Section 3 of the DV Act, one definition of DV Act. Section 3, my lord, DV Act, if your lordship will see, the first line, for the purposes of this act, any act, omission or commission or conduct of the respondent shall commit domestic violence. So, my lord, it has to be the respondent. Now, if your lordship will kindly see the definition of respondent, my lord. That will be, my lord, 2Q, my lord. Respondent means any adult male person. This was subsequently clarified by the Supreme Court that it can be female also, my lord. The adult male person who is or has been in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief under the Act. So there has to be, my lord, it has to be done by the respondent, and respondent must have a domestic relationship. Now, if your lordship will kindly see domestic relationship 2F. 2F, my lord. Domestic relationship, may I read, my lord? Domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or through a relationship in the nature of marriage, my lord. If your lordship will see the application at page 15, my lord,
there is, especially as regards this married sister-in-law, no allegations against them, my lord. Starts from page 16, my lord.
Well, let notice go at this is. Let the other side appear, we will hear and thereafter we will pass the
My lord.
heard Mr. Novas, learned counsel for the petitioner. This petition under section 528 of 2023, but petitioner has tried for causing domestic violence case number 28 of 2026 pending before the Court of Learned Judicial Magistrate First Class Regarding who are the petitioners. Namely Kamrul Islam, Enamul Islam, alias Enamul Islam, Habiba Parvin, and Sajida Begum, alias Sajida Parvin, and Abdul Basit. Abdul Basit. Where is the petition and the documents placed in record? Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Place the matter after 4 weeks. Recessal call for the scan copy of the record from the learned trial court. Place the matter after 4 weeks.
I will kindly fix a date, madam, since you lost interim, madam.
Interim pair of the petitioner will be considered after receiving the record from the learned trial court and on appearance of the other side. Place the matter on
On 8 September,
My lord.
18
Deeply uploaded.
item for. August, item number 42.
Yes.
পার্টে কবে খবরটা এসে the other side is present.
After some time, so F2 also. F2 is possible.
Okay.
Item 43.
Cover video again after some time.
Item 44 and 45.
Item 40, my lord, item 40.
Okay, no, no. Item 44 and 45.
May I please have a motion? Can we meet up with also for time?
Okay.
Forty-six. 46.
None appears for the petitioner on call. List the matter after.
46.
You are for? ED.
On behalf of our services available.
Letter on Mr.
A Banerjee on behalf of our.
Learned Counsel entered appearance on behalf of Mr. Ardhar Learned Standing Counsel for the ED. Office note dated 5/8/2026 indicates that neither ready card nor unserved notice issued to the respondent returned till date. List the matter after 2 weeks, awaiting service report upon the respondents.
Item 47.
May I please, Lord.
Yes.
We have filed this petition for quashing, my lord.
Hmm.
And
Whether notice served,
it was office note, my lord. It is not completed, my lord. We have taken the steps also, my lord.
you have taken a step.
Yes.
Heard Mr. Ali, learned counsel for the petitioner. And also heard Mr. Borthakur, learned additional PP for the state respondent. Office note dated 6/8/2026 indicates that service report is awaited. List the matter on Friday.
But I am paying for interim, my lord, for lordship kindly see the FIR, my lord. Case registered, my lord, under section 294 and 323 and 506. Not a single ingredient of 294 is available, my lord. Incident took place within the campus of the house. Now, other two offense, my lord, non-cognizable. And he is an advocate by profession, my lord. Due to some due to keeping the shows, my lord, altercation took place.
Will ascertain service of notice upon the
Case
respondent.
21, lord, you kindly see, my lord.
No. Let the first notice be served. In the
Till
meantime,
evidence, my lord.
they shall track the consignment in the website of the department and put up on up-to-date office note. Let it be on Friday. Right.
Obliged.
Item 48.
Pardon?
We have already picked up the matter.
This matter,
Yes.
when?
I'm not aware of
You are appearing on behalf of?
Harmit Kumar.
Item 48.
Yes.
When we turn today? You are for the respondent.
Yes. As submitted.
None appears for the applicant on call. However, Miss, your name,
As Khatun.
learned counsel, appearing on behalf of Mr. S. Moni, learned conducting counsel for the respondent present, opposite respondent opposite party present. List the matter after a week. In the event of subsequent non-representation of the applicant, appropriate orders shall follow.
49.
Good. Okay. Later, It has brought to the notice of this court that by order dated on 3/8/2026, the main bail application number 1775 of 2026 was withdrawn by the petitioner. In that view of the matter, this IA stands closed. Yes, Mr. Chakraborty,
May I present, Lordship? Lordship,
this is condonation petition,
condemnation petition of 75 days, Lordship.
75 days.
Yes.
Heard Mr. Chakraborty, learned counsel for the applicant, and Mr. Borthakur, learned additional PP for the state respondent. This application under Section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 75 days in preferring connected revision petition against the judgment and order dated 12/2/2026 passed by the learned additional session judge FTC Shivsagar in criminal appeal number 39 or 3 of 2025. Let notice be issued to the respondent stroke opposite party, returnable in 4 weeks. Step upon respondent number 1 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued since Mr. Borthakur entered appearance for the respondent number 2 can receive notice. However, extra requisite copy of the application be furnished to him during the course of the day, list the matter after 4 weeks.
Lordship. Obliged, Lordship.
51. 51.
None appears for the applicant on call, list the matter after a week. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
Of bail hearings. 26.
PCR is there.
Kindly after content.
27.
27 plus 63. 27 or 63.
27 and 63.
27 and 63 also, my lord, may kindly be taken up.
Lordship, in this matter, maybe adjourned because I have taken the ground of 36 in the supplementary list item, Lordship, in Amul Hawk. So matter is pending before Honorable Division Bench judgment, Lordship, on 12th. Whether 36 is mandatory or not, Lordship. So maybe taken up, and another matter is pending on 14th of the same affair, Lordship. That case is, Lordship, here BA 201826, Lordship.
Is it listed today?
No, that was listed on 14th, Lordship, out of same FIR. BA 2018. So for Enamul Haq is concerned. These three are
Okay,
of the same
after
FIR.
hearing learned advocates of both the parties, this application stands adjourned to be listed after third week of
36 or
27 or 63.
27, 63 same और 14 तारीख के बेले के टाके same
third
affair
or fourth.
तीनटा केस तीन जने के
26 of.
Along with BA number,
BA 201826
give the number to the court master.
that is fixed on 14th, Lordship.
28.
20 is also I am here, Lordship. I need some time, Lordship, some accommodation. I want some instructions, Lordship. In this case also 36 grounds have been taken and 47, 40 don't taken, Lordship. This is NDPS commercial quantity case, Lordship. Maybe on next Monday, Lordship, if possible.
On the pair being made by Mr.
On 17th, Lordship, if possible.
Further learned counsel for the accused. This matter stands adjourned to be listed on
17th, if possible.
20. 20.
20, Lordship.
Item 29.
Lordship, actually, we had item number 27. I think it got connected with this senior's matter.
pardon.
For item number 27.
63.
Okay.
27.
Okay, the date.
Twenty-nine. May it please your lordship. On the last occasion, it was submitted that charge sheet was filed, so charge sheet was called, a scanned copy of the charge sheet was called for.
Like, but the order was charge sheet was not filed, the 48 lordship.
Okay, please, 1 minute.
Days, yeah?
54 days. Foxo, 18 and 4.
So trial court record has been received.
Received, but earlier lordship was submitted with charge sheet submitted on section 4 and 18. But as for the trial court record, the last order, I have flagged the order. So that trial court charge sheet was not filed before the court till 3826. That's why record was not. Charge sheet was not filed before
No,
the
from where this record came?
because the instruction the charge sheet submitted. That's why they asked for record. But charge sheet is not submitted before the last order. We have visited with lordship. The charge sheet submitted by charge sheet number 186, dated 29/6/20.
No, this court has received the record. From where the record comes?
Lokhimpur Road. Lokhimpur, not Lokhimpur PS lordship.
The record from the city part was there.
Only CD part.
KSI part was there.
Okay, where is the record?
Scan.
A respondent number to Dhaneshwari Kolita and Babul Kumar, Sundar Kumar Gola. 9. Well, no,
Almost one I record. আমি ফটো পাও না ওর সাথে ফটো দিন আসলে আছে arrested on 17/6 arrested.
Hmm?
He was arrested on 17/6. Lordship, if lordship peruse the FIR, there's nothing like the POCSO section is attracted. Lordship, that
Additional PP has pointed it out that though LCR trial court record has been received, yet the copy of the search sheet is not available with the same. And in that view of the matter, it is provided that a registry shall call for the complete record of GR case number 528 of 2026 arising out of Lakhimpur, North Lakhimpur PS case number 192 of 2026 under section 65 within bracket 162 74 127 to BNS related section 4 stroke 18 of POCSO Act. List the matter on Friday. We will try
next Monday, Lordship.
Monday.
Next Monday.
70,
Deeply up.
31.
Lordship, I apologize for interrupting. Lordship, this is regarding item 27. Lordship, the
Take
another
a date
bill is.
from- Take a date from him.
Okay.
Post diploma. 29.
Maybe, Lordship.
Yes.
Item 30.
Are Mr. Islam, learned counsel for the accused, and Mr. Kusami, learned counsel for the learned additional PP for the respondent. Number one, state respondent number one. Office note dated 6/8/2026 indicates that service report is still awaited, though the scanned copy of the TCR has been received. Accordingly, it is provided that Mr. Goswami shall obtain the service report from the officer in charge of jurisdictional PS on Thursday.
Report.
32.
My lord, I'm sorry, my lord, item number 51, that was non-appeared, my lord. Maybe
Take a date from him.
May I please, your lordship? But I'm behind the bar 48 days today, madam. Your lordship was kind enough to call for the case diary, madam. Madam, meanwhile, two of the co-accused have been already analyzed and failed. I'm placing the order, madam. But I was the driver. My service was hired. And allegation is that this other accused person, those who have been granted bail, they opened fire in front of the house of the informant with a view to commit equity. But thereafter, they left the place. They have not entered to the house of. I'm not for that. I'm for driver, madam.
Yes, any material against him?
Petitioner is the owner of the vehicle, but the offense is registered under section 3110 for preparation to commit the party. And armed safety is also there on that particular night, my lord, on 23/6.
No, against the present accused, is there any material?
Some of the local, my lord, witnesses who at that time, two persons, my lord, witnessed the incident. They fled away along with that vehicle. That vehicle number was noted down by the two witnesses. And from the, he is the owner of the vehicle.
That I admit already. I owner and driver. I have driven the vehicle, and these people are left, travel in my vehicle and left me in my vehicle.
And from the severe analysis, two persons initially arrested, my lord. And thereafter, from their statement also, they stated that.
So they have been enlarged on bail.
Okay, we'll go through the case diary and we'll pass the order. Borthakur, you hand over the case diary. Correct.
Item 35.
May I please, Lord?
Yes.
Lordship, this bail application has been filed by the accused persons.
There are five, my lord, bail applications which have been listed today in different courts arising out of the same case. It is regarding, my lord, fraudulently, my lord, obtaining input tax credit, my lord, from the GST authorities. Thereby defrauding the state, my lord, in crores of rupees. It's a total racket, my lord. So, my lord, three.
So the case diary is available with you.
Case diary available, can it be taken up tomorrow along with all other two cases? 5 cases will come up, my lord. One is listed in court
No,
number 20.
there is no problem, but he is from a
Yes,
Eton.
madam, exactly.
But my lord, case that I have got, I will have to flag mark everything, at least I can fetch before reporting. Tomorrow, my lord, morning.
My lord, Lordship, perused the application.
The big packet, my lord, who has defrauded the state of Assam with crores of rupees. All are from Bihar, some from Gauhati. My lord, I will place everything, my lord. That's why, my lord,
Mr. Kato, you can appear for the VC also tomorrow.
And another difficulty, my lord, if perused my bail applications, my lord, in the ground of arrest, my lord, it has been categorically mentioned why, my lord, the STF has arrested me, my lord. That is the only, my lord, ground, my lord. I am nowhere involved, my lord. Admittedly, FIR says so many things, my lord, but my involvement is only I am the, my lord, the caretaker of that building, my lord, where the business was taking place, my lord. I was the caretaker, my lord. And if only for the purpose of, my lord, the taking care of the premises, my lord, I was there and I was arrested by the police.
Let us do one thing. Let him complete his argument today.
my lord.
Tomorrow he can argue.
Yes, I will.
And he can appear tomorrow through VC.
Much obliged.
Today you complete your part.
Deeply appreciated. My lord, if lordship, my lord, peruse, my lord, may I take your lordships to the page number, my lord, 30, my lord, directly, where, my lord, my involvement is, my lord, has been, my lord, clearly stated by the STS, my lord. Page number 30 of my first bail application, my lord. Item number 33, my lord. Page number 30, my lord. Ground of arrest, my lord.
Yes.
My lord, my ground of arrest, my lord, has been categorically mentioned, my lord. During the investigation, it was found that although this so and so, who is the proprietor of malad Ida Bitumix malad. Even I'm not the malad involved malad. And she was not even physically present say, at the principal place of the business and the day-to-day affairs and activities of the business, the premises were being looked after and managed by Ajay Kumar Yadav malad at the rate of Ajay Prasad malad, that is me malad, including the management and the operations of the business premises, handing business records, etc. malad. The next paragraph malad 2, the Ajay Kumar Yadav at the rate of so and so has been responsible for the availing ITC fraudulently along with uh, Sahina Sultana, the Sabas Haider, the Muhammad so and so, malad Amit Kumar Jha by criminal conspiracy and sitting malad. 3 malad. The accused Ajay Kumar Yadav at the rate of so and so, who is caretaker of Malad. This is important, Malad. I am the caretaker, Malad. I admit that Malad, that responsibilities, Malad. Caretaker of Ida Bitumix, GST number so and so, in principal place of the business in Gauhati. MS Ida Bitumix the has a bill, the input tax the credit amounting to so and so rupees, and so by fraudulent means and arising and using deposed invoices which is detrimental to national economy. Upon issuance of the GST so and so number, so and so. Malad, here I'll pause for a moment, Malad. It has been clearly mentioned that I am involved only as a caretaker, Malad, of that premises, as I've already pointed out, Malad. Now, Malad, this company is not belongs to me. Malad, the responsibility of this, Malad, the company is not belongs to me, is not to me, Malad. And the responsibility, Malad, whom this company has been given, may I take a lordships to just for a moment, Malad, just to clarify all this, Malad, the Malad aspect. Page number, Malad, 28 back, Malad. Malad, I am a small person looking up, Malad, doing my, Malad, working under them, just for, Malad, my, the visits. It is page number 28, Malad. Ground of arrest of Amit Kumar Jha, Malad. He is the person who is responsible for all, Malad, this business, as Lordship has already seen in the page number 30, Malad. The accused person, arrested accused Amit Kumar Jha is the authorized representative of 3 numbers of firms, namely Ida Bitumix, Malad, where I was caretaker, Malad. Ida Bitumix, MS Barrel Bitumix, Bitumen, and so and so, so and so. All of these above 3 firms had predominantly availed the info tax credit by generating the PAC invoices from the non-exist taxpayer and from the taxpayers whose the registration has been cancelled so moto by the Department of the various the states in lieu of the non-existence. Malad, just for a moment, I'll again Malad pause here, Malad. Malad, it has been clearly mentioned that he is the person who is responsible for all these 3 Malad the firms. And Malad, importantly, Malad, the person who is responsible for this all 3 firms, Malad, has been granted bail by this honorable court.
When?
Malad, annexure, admittedly, Malad, annexure 5, page number 65, Malad. Page number 65, Malad. Malad, he is the person who is responsible for all this business, Malad. I am, Malad, as I have pointed out, caretaker in that premises, Malad, where the business was took place. Page number 65, Malad. Out of same FIR, out of same, Malad, same section, everything, Malad. Page number 65, Malad. It is starts from page number 65 and the relevant, Malad, page number 66 and 67, Malad. With these terms and condition, Malad, the order dated, bail order dated 27/7/2026, Malad.
Okay.
Yes, my lord. My respectful submission before your lordship is, my lord. My lord, he was working as caretaker in
So,
diplomat.
so how long you were behind the bar?
My lord, it's been almost around 2 months, my lord, now. My lord,
Months.
I was arrested on 5th June 2026. 15 June 2026. my lord. Only 5 days, 4 days left, my lord.
Okay.
My lord. This is the, my lord, my only involvement, my lord. And my lord, I have small children, my lord.
In
who-
the other two matters,
Other two accused persons, my lord, as lordship has already seen. In the same
Jitendra Sahu. Item number 34.
34. Yes, my lord. My lord, here, admittedly, my lord, I'm the proprietor of this firm, my lord. But this, my lord, again, my firm was, my lord, taken responsible by the same accused person, my lord. Page number, my lord, 30.
You are the proprietor of the firm.
Yes, my lord.
And
But
Amit Kumar Jha,
yes, my lord. He was
He-
my lord, the authorized representative, my lord. So
authorized.
therefore, my lord, I
representative.
am nowhere involved, my lord. There, if huge amounts of rupees are involved, my lord, that has been done by the other party, my lord, other accused person, my lord. I am nowhere, my lord, involved. That's because this is a matter of GST, my lord, and the electronic records, my lord. Everything has already been taken by the, my lord, the STF, my lord. And all documents, my lord, the custody, everything, my lord. It is electronic records also, my lord. So chances of the, my lord, the hampering and tampering of the evidences is also not arises because, my lord, by now, my lord, they have already taken possession, my lord. Everything, my lord. And he was also arrested on, my lord, the same date, 15 June 2026 from Calcutta, my lord.
Okay. In the other matter 35,
Yes, my lord. Here also, my lord, he is the, my lord, the brother of this accused, the Jitendra So. Deepak So is also the brother, my lord. He, both were, my lord, my lord, the proprietor of this firm, my lord. Ida B2 Mix, my lord. And he's also nowhere, my lord, involved, my lord.
yeah, if the proprietors are not involved, who are involved?
Involved, involved to that extent, as the STF has clearly mentioned in their, the findings, that the responsibility is the, the caretaker. Lordship has already seen that page number, uh, 28, wherein it has been categorically mentioned, by the STF themselves, and no money has been recovered from me, no, the amount, the other incriminating documents has been recovered from me, It is the sole responsibility on the part of the, my authorized representative, whom I authorized, It is also same, the page number 28. So therefore, by now, the STF has, investigated everything, Nothing has been found against me, Without my knowledge and consent. This all has been done by the respective
Knowledge
commission.
and consent, that is the subject matter of trial. And this is that cannot be.
Admittedly,
cannot be
By now,
asserted.
everything has been completed, investigation is almost done, There's
So,
nothing, remains to be investigated further, At this stage, I may be allowed to go on,
Tomorrow after going through the case, there we'll pass the order. We'll hear the other two matters. You are in other two matters? No.
Other
two, my lord, different.
Different. Heard Mr. M. Kato, learned counsel for the accused persons in item number 34, 35, and 36. And also heard Mr. B. Gogoi, learned standing counsel for the STF. Mr. Gogoi has produced the case diary before this court. Additionally, Mr. Gogoi has produced the case diary before this court and submits that he could not go through the same and he pressed for listing the matter tomorrow along with BA number What are the number?
I will provide the number.
My lord, item number 34 and 35.
Tomorrow. Okay. Pair allowed. SSL is the matter tomorrow as parted.
My lord. Deep development.
Item 62. 62.
Wait, please, Your Lordship. For application, my lord. Arrested on 6/4/26, my lord. More than 100 days, my lord.
How many days?
More than 100 days.
More than 100 days.
But here, it's commercial quantity, my lord.
Commercial.
I have been apprehended with
Where is
Java
the
tablet, my lord. 1,000
where is the FIR?
FIR at page 17, my lord.
17.
Page 17.
So what is the contraband substance?
Yeah, my lord, is Java tablet, my lord.
Java tablet.
Tablet,
What is
which,
the quantity?
weight is 1,085 gram. It's a commercial quantity, my lord.
Commercial quantity.
But nothing has been seized from my conscious possession, my lord. I'm with the co-accused, my lord. I was waiting for that person, Abu Hussein, my lord. The investigation officer, investigation agency has apprehended me along with that Abu Hussein, my lord, where I was waiting for him in the Badalpur railway station, my lord. I've been asked to give a vehicle for his communication, my lord. So I was waiting there. In FIR also, my lord, page 18, my lord. I'm relying with a judgment, my lord, here. The Surat Singh versus State of Himachal Pradesh, my lord. Surat Singh versus State of
No, you
Himachal
come to
Pradesh.
page number 18.
lord,
During search,
Yes, my lord.
below noted articles are recovered from the conscious position of the apprehended person, namely Ali Ahmed alias Ali Hussein
My
Law
lord,
Court.
my lord.
So the petitioner hearing
Yes, my lord.
and Abu Hussein and sees the Yaba tablets.
Yes, my lord.
So is it not your conscious possession?
No, actually, my lord, this thing has been seized from this, mainly from the Abu Hussein, because I was waiting with the vehicle, my lord. I have stated in my paragraph 7, my lord. In my
That is
petition.
your statement to be considered at the end of the trial, but
My lord.
at this stage, this FIR shows that it was recovered from you. Where is the seizure list?
Seizure list at page 27, my lord.
27. 27.
But I was called by the Abu Hussein, my lord, to the railway station.
That is your defense. You can establish it during the trial. But here we only see the prima facie case.
My lord.
After going through the FIR, the forwarding report, and also the seizure list, can it be said that no prima facie case is made out against you? Portakor, what is the stage? What is the statutory period here?
180 days. 180 days.
180 days.
FSL report also received, my lord.
FSL report received.
Well, almost ready for submission. My lord, subject, my lord.
Then how can you satisfy the twin requirement of section 37?
I have stated in my paragraph, my lord.
Paragraph number?
Paragraph number 9, my lord. 9. About the seizure, my lord.
So perusal of the FIR indicates that notice was given to you under section 42.
Yes.
Hmm?
At the time of apprehension, my lord.
Hmm? Fifty-two notice was also given.
That is given, man.
50 notice under 50, yes.
All procedures complied with.
Okay. We'll see the case there.
Man.
Next.
Oh, bless you.
Okay. We'll resume after 5 minutes.
Is my lord regarding my lord prior to 8 years ago. So my lord, the lordship may kindly page 17, my lord, FIR.
One 64 is there, 183 now, lordship. It is there, medical is also there.
What is the age of the victim?
Victim, my lord, at the time of lordship, kindly see page.
Victim. Okay. What is your summation?
The other accused practitioner with respect to the will take effect for 1 year. Will is with consider your system. There are allegations that we have taken the.
Okay, we'll see.
Yes.
Protocol CD received here.
FIR is at page number 13, my lord.
So on the other day, a question was put to you regarding maintainability of this petition,
Yes, my lord.
where the commercial quantity of contraband substances were recovered from your possession.
I have searched, my lord. So far, I have searched, my lord. So there is no explicit bar, my lord. Although honorable court has rejected anticipatory bail basing on the circumstances and the facts of every cases, my lord.
Okay.
So far, here in this case, my lord, we should read along with the drugs and cosmetic rules, ma'am. Because I have a pharmacy, my lord, I have a valid license. And under the said license, I have the license to regulate, purchase and store and sell some kind of drugs, my lord. And those drugs were seized from my pharmacy as well as from my godown, my lord. And for that, I have bills for purchasing of those drugs, my lord, after paying all the requisite taxes, my lord. And because at the time of raid, my lord, I was not in my pharmacy, I could not produce those bills before the police. And in the meantime, police have arrested my employee, my lord, sealed my pharmacy and seized those, my lord, cough syrup, my lord. FIR is at page 13, my lord. The FIR reflect that, my lord, where this cough syrup were recovered, my lord.
From my lord, pharmacy, 20 bottles of cough syrup has been codeine phosphate, and from my godown, 193 has
Mm.
been seized, my lord.
Mm.
And this, my lord, codeine phosphate come under schedule H and H1, my lord.
Mm.
And so far the license is concerned, my lord, I have annexed those license. Some, my lord, drugs which are scheduled in X that is not permitted to sell or store, my lord. But so far, this drugs, my lord, it can be used for medical purpose. If until and unless I use this illegally or illegally store, my lord.
Where is the license?
License is the page number 19, my lord.
Mm.
Under 61A, it was granted, my lord, from 20B. License to sell, stock or exhibit or offer for sale or distribute wholesale drug other than those scheduled in Schedule C, C1 and X, my lord.
Whether these cough syrups which were recovered and seized from your pharmacy
My lord,
falls in the schedule C, C1 and X?
no, my lord.
No.
It is not. It is
That-
H and H1, my lord.
Then,
My lord.
then how
Uh,
can you are protected? How you are protected?
Because I have the license, my lord. On the basis of this license, I have store, I have
No,
sell,
no,
my lord.
if you are granted license for selling items mentioned in the schedule C, C1 and X.
Other than those specified in schedule.
And
If
if
I
the
export this,
seized
my lord,
contraband were not permitted to sell you by the aforesaid license, how can you sell it?
no, this is not C, C1 and X, my lord. Schedule drugs. The cough syrup, which were seized from my pharmacy, my lord.
Mm.
These were not specified in Schedule C, C1 or X.
No,
my lord.
that's why.
So other than those, I can sell, my lord. So far, this scheduled drugs I cannot sell, my lord. C, C1 and X.
Mm. And the contrabands were mentioned in this schedule,
No, this is not this schedule. This is H and H1, my lord.
H and H1.
And
So
I have
you are allowed to sell H and H1.
my lord. Other than this, I can sell, my lord, and I have purchased this from. I have the GST invoice also, my lord, which I have annexed in 26 page number. And everything I have recorded in my registered, my lord.
H
Which is-
and H1. Where
H
is
and
that
H1.
schedule?
H and H1. In this regard, my lord, for your lordship easy reference, I beg to refer an order recently passed where this kind of matter has been dealt with. If your lordship may please, my lord. Any copy of the, copy of the, copy of the- So there is quantity is more than here, my lord. These are only for sale for medical purpose, my lord. Broncough, my lord. It was in 26 serial number 1, my lord. And whatever I have sell, my lord, I have maintained a register. And unfortunately, that register is in my pharmacy and that was sealed, my lord. I could not get it, my lord. If at that time I was in my pharmacy, my lord, I'll produce everything before the police, my lord. And similar issue is involved, my lord, here also, my lord.
Okay. Mr. Bortapu, hand over the case. Then. Mm.
If FSL was called for nothing, they have not received the FSL. It will be required because the cause of death is not detected, Lordship.
FSL not received.
Not received.
Will tell them that they are the family members, my lord, who are residing separately from the accused number 1, my lord. This is just, my lord, there is a-
Maybe
there is
let
a
the
baby, my
FSL
lord,
come.
is about 3 years, my lord. That male baby is my lord, with the petition number 3, my lord, or grandmother, my lord. And this is just not, if this FSL is not received, my lord, Till then, my lord, they may be.
No, no, we'll fix a short date. They will procure it. Heard Mr. Islam, learned counsel for the applicant, and also heard Miss. Your name, please? A Begum. Learned counsel, learned additional PP. Ms. Begum submits that the FSL report has not yet been received. Accordingly, it is provided that Ms. Begum shall produce the FSL report before this court on Thursday or Friday.
Not Friday.
Friday. Friday.
My pleasure, Lordship. Earlier, CD was called for your Lordship. Lordship, here victim is a major, your Lordship, is 19 years, your Lordship. There is a law payers, your Lordship. But in FIR allegation of rape, your Lordship, I also annexed the application of marriage, your Lordship, page number 15 and 16, your Lordship. Page number 15 at bottom. Page number 15 at bottom, your Lordship, name of the petitioner.
Message was sent.
And 16 is the victim's name, your Lordship. In the
Is there
meantime, I
not
clear
received?
for some protection, your Lordship. It is already settled, your Lordship. She is 19 years, your Lordship. And on 17th July, your Lordship, I applied to your Lordship. I also annexed the admit card, your Lordship. Page number 14, your Lordship. 14, 15, and 16, your Lordship.
Is there any required?
It's a marriage application before the sub-register Bilashi Kara, your Lordship.
Already message sent.
Some protection may kindly give me. Please run after me, your Lordship.
Okay, on
Already
Thursday.
settled.
Friday.
No, Thursday. Heard Mr. A R Karim, learned counsel for the applicant, Ms. Begum for the respondent.
Okay.
Additional PP for the state respondent. Ms. Begum submits that CD has not been received and press for granting some time. They are allowed. List the matter on Thursday.
13.
Item 64.
My pleasure, Lord.
The service report received here.
Lordship service report is not.
You have taken a step
Lordship,
upon respondent.
Lordship, I have checked the office note, Lordship. It's showing that it's not taken, Lordship. 1 week time may be given, Lordship. We'll take
1 week time.
Lordship.
Heard, Mr.
I am in, Lordship.
Learned counsel for the applicant, then Ms. Begum for the respondent. Ms. Begum, no, the learned counsel for the applicant submits that he may be granted 1 week time to take step upon respondent number 2. They are allowed. List the matter after.
Question 24.
24th of 24th of August. And Ms. Begum shall produce the service report upon the respondent number 2. After having obtained the same from the officer in jurisdictional PS on that day.
Obliged.
Item 42.
My lord, we have received the bottleneck number today, my lord, after the container was implemented.
At 2 p.m. At 2 p.m.
At 2. Timing 43.
And this is the last one. Has been given by the department.
Finance department.
Yes.
And now, how much time it will take to complete the process?
Now, Lordship, it is the education department, they can process it because necessary.
No, I am asking her. After 10 days. After 10 days.
My friend's name may be someone.
Now my name might not be required.
Okay, okay. No, you are not a party here also.
Yes, my lord, yes, my lord.
I was only assisting the court.
Ah, yes. Heard Mr. Islam, learned counsel for the petitioner. Ms. Sophia, learned counsel for the contender. And also heard Mr. A. Soliha, learned standing counsel for the finance department. Mr. Soliha has produced today one status report in this matter, and on the basis of the said report, he submits that the finance department has accorded its approval by e-file number 747006 dated 5/8/2026 towards creation of a post of tutor for provincialization of SK Mohammad Zakir Hussain in compliance with the order of this court dated 10/4/2023, passed in WPC number 3452 of 2021 with effect from 1/1/2021. In view of the aforesaid report produced before the court today by Mr. Soliha, his service stands dispensed with, and Ms. Sophia Learned, counsel for the contender, submits that she may be granted 10 days time to complete the entire process. Where allowed, list the matter on 7th of September.
Obliged.
On that day, Ms. Sophia shall produce the compliance report before this court.
Items for admission, item 18.
So here also the concurrence of the finance department is awaited. So let us wait for some time.
Or lordship may dispose of lordship by giving a specific time frame to do the entire process, lordship. Because she has retired long back, lordship.
No,
My
that's
prayer
right,
in that-
but in the event of non-compliance, then again you have to approach
Yes,
this
Lord.
court.
That is true.
Better we should wait for
Lord.
some time. Mr. Soliha, here also you have to assist this court.
There we have already a party.
Your party?
Yes, yes.
Okay. So you have received the this proposal?
This we recently launched.
Yes.
Recently,
This was 7th of August, Lordship, this proposal.
7th of August.
Yes, Lordship.
Okay, then on next date you obtain the
We will give you logical conclusion. There was some date of joining. There was some
yes, a little issue.
Yes, yes, Lord. Now we will finish it.
Okay. Heard Mr. Das, learned counsel for the petitioner, Ms. Terangpi, learned standing counsel for the secondary education department, and Mr. Solina, learned standing counsel for the finance department. Ms. Terangpi has produced one letter dated 8/7/2026, and on the strength of the said letter of the Deputy Secretary to the Government of Assam addressed to the Standing Council Gauhati High Court, she submits that the proposal has been sent to the Finance Department for concurrence. And immediately on receipt of the concurrence, the approval No, proposal of the petitioner, proposal in respect of the petitioner for pay protection will be considered. Let a copy of this letter be furnished to Mr. Solia, learned standing counsel for the finance department, who shall obtain up-to-date status in respect of the said letter and apprise this court on after 1 week.
Sometime, 2 weeks, Lordship, because we have just received it, Lordship, we'll bring it to the logical conclusion and produce the necessary documents. It can be perhaps, Lordship, before also, Lordship, I'm asking for 2 weeks accommodation.
21st.
Lordship.
The letter produced by Mr. MP today, we marked as annexer X, and we take to the record.
Item 19.
May I please, Lordship? Lordship, in this case, my lord, I am not the FIR named person, my lord. My son, allegation is that my son has still make a theft, my lord. Therefore, the parents has been doubted, my lord. The FIR is at page 8, my lord, and the last line, second para last line, I have a doubt that the parents of Amit Roy is involved in the incident, my lord. This is the only sentence. The police has filed the charge sheet under 380, my lord, under section 380, my lord. Nothing is against me, my lord. In this, the police has recovered nothing from my position, my lord. Nothing, no witness, nothing, my lord.
What
Just
is
because
this?
at the time of harassing by the police, my lord,
No,
I took a
at-
bail, my lord.
What is this? The case is pending now.
It is under appearance, my lord.
Appearance.
My lord. In every date, I had to appear, my lord, without having any allegation against me, my lord. And the learned,
You are
I am Sabitri Rai, my lord.
Savitri Rai.
Not a single word against me, my lord.
You were the mother of the
Amit Roy, my lord.
Amrit Roy.
My lord.
Amrit Roy. Okay.
My
Amrit
lord,
Roy is accused number 2.
My lord.
And accused number 1 is Sunil Mandal.
My lord.
Where is the FIR?
FIR is at page 8, my lord. That is type copy, my lord. And the vernacular is at page 12, my lord. My lord,
Yes, the
The party is not available. Our implications are there or not, but otherwise procedures taken for Lordship and all this council is there. But we don't have
my lord, no seizure list against me, my lord. Nothing. I have annexed the seizure list, my lord. If anything could have been seized from me, my lord, then something can be believed, my lord. Only because of the mother of an accused, my lord, that cannot take me. That cannot be taken into consideration, my lord. And the learned court below, while granting bail, my lord, that is at page 28, my lord. My lord, may kindly peruse paragraph 3. However, in the FIR, there is not even a single whisper about the involvement of the parents present to petitioners, that is Sabitri Roy and Umesh Roy. Merely because Amit Roy is their son, they cannot be held guilty of commission of theft in the house of the informant. And the principles laid down, Lordship is very much well acquainted, my lord. The principles laid down in the Bhajanlal case, my lord. Third principle is that if the investigation.
no, that's all right. Now the case is pending at the stage of
Appearance, my lord.
So
And only
whether
because
the statement of the witnesses are available with you? No. You have
Actually,
not been
as per my information, no statement, nothing recorded. The police did nothing, my lord, in this case. Only because I have taken bail at the time of that incident, my lord. My name has been put into the, that means only that column, my lord. Nothing in the,
No.
that column is name and accused, name and address of the
Mr.
accused,
Mr.
person sent up
Sanda.
for trial, my lord.
Mr. Sanda.
My lord.
Is it not necessary for this court to verify the statement of the witnesses?
Lordship, very much necessary.
So let the record come.
My lord, it's
If,
court date, my lord. I was.
there is nothing in the case ID, then definitely we will allow your petition.
Lordship, it is from the SDJM to Kamrup Metro, my lord. Maybe kindly fixed on Friday.
SDGM 2.
Yes, my lord.
No,
SDJM,
no,
Kamrup Metro, my
SDGM
lord.
2.
SDJM 2.
Okay. Heard Mr. Sundar, learned counsel for the petitioner. Then Mr. Goswami for the respondent. Additional PP for the state respondent. Mr. Goswami has pointed it out that though the scanned copy of the record has been received, yet the CD part is not available. And in order to dispose of the present petition, perusal of the CD is very much necessary. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess shall call for the scanned copy of the case diary, fixing the matter
On 14th, my lord. On 14th, this Friday, my lord. This Friday.
Already commented.
My lord,
Monday, next Monday.
Monday. Lordship.
Monday. 2. Mr. S. Das for respondent number 2.
Diploma.
The urgently required. This is quashing petition. Case is surseated
Yes.
under section
105.
105.
Yes, Lordship. Culpable homicide. BNS.
What is 105?
Culpable homicide.
Homicide.
Yes.
Heard, Mr. Your name?
R.A. Ahmed.
I Ahmed.
R.A. Ahmed.
R.A.
Ahmed.
Okay. Learned counsel for the petitioner and Mr. Ahmed, learned counsel for the respondent informant. Informant and Mr. Goswami for the respondent number 2. No, respondent number 1. Respondent number 1. Mr. Ahmed, appearing for the respondent number 2, submits that he may be granted some time to file objection in this petition. Fair allowed, list the matter on. When?
Next week.
Next week. 19th of August.
21.
Lordship, in the case of the petitioner is that 2 number of FIR has been filed by the complainant in 2 different districts. One is in Bojali district and the other is in Nalbari district, arising out of the same seizure. It is an NDPS case, Lordship.
NDPS?
Yes. Out of the same seizure, 2 sets of FIR has been lodged. And Lordship, in the meanwhile, the coordinate bench was pleased to stay the proceedings of pending before the Bojali court, which was filed subsequently by the complainant. And the TCR was called for from the Bojali court. And my prayer is today is that, Lordship, the TCR from the Nalbari court has not been called. That was left to be called for, and we have filed an additional affidavit calling for the TCR from the learned Nalbari court, wherein the first case was registered. And Lordship, the interim order is there.
Heard, Miss, your name, please?
Albanic.
Learned counsel for the petitioner, Mr. Goswami for the respondent number, for the state respondent. The learned counsel for the petitioner, referring to the additional affidavit, submits that in connection with same seizure, 2 set of FIR were filed, one in the Bojali district and the other in Nalbari district. Upon which, what are the case numbers?
The one pending before the Nalbari court is NDPS case number 1/23, and the by charge.
In Bojali?
Bojali is also same 1/23, but the charge sheet number is different. The one pending before the Nalbari court, the charge sheet number is 69/2022. arising out of Tihu PS case number 74/2022.
And in connection with the FIR laws in the Bozali district, search sheet number 1188 of 2022 dated 38/11/2022 has been filed before the Court of Learned Special Judge NDPS Bozali, and in respect of the FIR laws in the Nalbari district, search sheet number 69 of 2022 dated 38/10/2022 has been filed. And though the record of Bozali record of search sheet number 1188 of 2022 has been called for by this court, yet the search sheet of Nalbari yet the search sheet number 69 of 2022 dated 38/10/2022, which has been filed before the Learned Trial Court at Nalbari, has not yet been called for. And in order to adjudicate the issue raised in this petition, there is a requirement of calling the record of Tihu PS case number 74.
Yes, Tihu
Tihu
PS.
PS case number 74 of 2022.
NDPS case number 1/23.
Corresponding NDPS case number 1 of 2023, pending before the Court of Learned Special Judge NDPS Nalbari, may be called for. Accordingly, taking note of the submission of Learned Counsel for both the parties, it is provided that recessal call for the Tihu PS case number, no, NDPS case number, special NDPS case number 1 of 2023, pending before the Court of Learned Special Judge Nalbari.
Yes.
They call for fixing the matter on
Lordship, the interim order may be extended till the next day.
26 August.
26 August. Interim order passed earlier shall continue.
And 24.
Till then.
May I please, Your Lordship? Lordship, today record was called for from the Kusaigaon PS case number. Your Lordship, matter pertaining to Jimma petition has been rejected by the trial court, Your Lordship. If Your Lordship will find at page 23, Your Lordship, for a moment, the impugned order, Your Lordship.
So the report was called for.
Yes, Lordship.
Report received.
Not this, Lordship.
And up.
Let the report come.
Lordship,
Whether you have sent the requisition.
Second equation, Lordship, but report is not received yet, and also call for the record also. No, report, only report. So it's not a possible time for the report. Lordship.
Can it be on Thursday?
Lordship.
Heard Mr. Akan, Learned Counsel for the petitioner, and Mr. Goswami, Learned Additional PP for the state respondent.
Otherwise, Your Lordship, as per the judgment of Sundar Bhai Ambalal Desai, Your Lordship, that judgment has been
But
covered.
that's all right, but
And
we
as
have
per
to see
section,
whether
subsection
the
five-
investigation is completed or not.
Yes, Your Lordship. As per the subsection 5 of section 11 of Assam Cattle Preservation Act 2021, also there is a principle. The Learned Magistrate has power to grant the Jimma, furnishing the bank guarantee, Your Lordship. That may be considered also.
Pardon?
Only with the first date. We have sent the request, Your Lordship. As per subsection 5 of section 11 of Assam Cattle Preservation Act 2021, has been power given to the magistrate of first class. Magistrate of first class can allow the Jimma petition of the seized vehicle subject to furnishing the bank guarantee, equivalent balance value of the seized vehicle, Your Lordship. So that may be also considered by that court below, Your Lordship.
No, your petition was rejected by the trial.
Rejected only because of if the vehicle will give the release to the petitioner, that it will be effect for investigation. And in the judgment of the Sundar Bhai Ambalal Desai, there is a clearly mentioned a vehicle which has been seized, it
Maybe.
cannot be kept for
That is there,
month.
but at what stage the power has to be exercised?
In a trial also.
Trial,
Yes, pending the inquiry also.
pending inquiry.
Yes, also.
No, is it not necessary to see whether the investigation is completed or not?
No, Lordship, during the pendency of trial inquiry, magistrate can give the the vehicle which has been seized.
Without
with the
giving,
after
without giving an
there is the
opportunity to the
report of the police
investigating
report.
officer to complete the investigation.
Yes, Lordship.
Huh?
So
Is
during
it?
the pendency of the trial, that can be also allowed. So
Hmm?
there is a judgment passed by the divisional bench of our High Court also. May I?
Let the report come, we will consider your prayer.
Lordship. Sure.
কি হলো লাইনটা? Mr. Goswami submits that though a report was called for from the IO concerned regarding the status of investigation, the same has not yet been received. Accordingly, it is provided that Mr. Goswami shall produce the report before this court on Thursday.
Diploma.
Section 23.
Kindly the peruse the order, last order, my lord, 4/8, my lord. But till that no affidavit has been filed, my lord.
Yes.
We are appearing on behalf of respondent number 2 and 3 and 4 on behalf of Mr. M. Sharma.
M.
Mukesh Sharma.
Hmm.
As senior counsellors, we have filed our affidavit in reply. During the course of the day, we will file.
Okay.
There is a observation, my lord. If not filed, my lord, then interim will be considered.
During the course of the day, we will file. It already signed, we will file.
And there is also, my lord, the initial order also filed, my lord, on 4/6.
Okay, Mr. Padgiri, they will be filing during the course of the day. So let it be on next Monday or Tuesday.
Next, my lord. It was fixed on, my lord, 28, my lord, 2208, my lord.
Okay, before that day, we will face the matter. Heard Mr. Padgiri, learned counsel for the petitioner. Also heard Mr. Goswami, learned additional PP for the state respondent. And Mr. Your name?
K. Golden.
Learned counsel appearing on behalf of Mr. Sharma.
Yes.
Learned standing counsel for the Central Bank of India. And he submits that during the course of the day, the required a reply will be filed. Accordingly, it is provided that SSL lays the matter along with the reply on next Monday, Tuesday, 18. Okay.
You are.
Petitioner is seeking tracking of the criminal case. The case relates to manipulation of physical efficiency data during a recruitment process.
During?
Yes, so the FIR, your lordship will find at page 27. The petitioner is not named in the FIR. Only link, her name came up in the charge sheet. And only link is that the CDR, her phone number was found in the call details. Right. And in the statements recorded under section 161, also her name is not there. There is no allegation against her.
Kindly see the FIR.
Received, Lordship.
PCR received.
We have not gone to the records yet, Lordship. So I pray for.
Okay, we'll take it up at 2 o'clock. You, in the meantime, go through the statement of the witnesses.
Fine.
At 2 p.m. then.
Fine.
হ'ব দুটা আৰু কিবা আছে নেকি নাই?
Ending to
2 p.m. at.
ending to ending 26.
Wait, please, your lordship. Lordship, this is a regular bail application. This petitioner in jail custody for 93 days, lordship. Her charge sheet has submitted, TCR has come, lordship. Kindly come to the FIR, lordship. It is only my contention, lordship. It's a violation of section 58 of the BNS, lordship. He was produced, lordship, after 24 hours, lordship. May I take you, lordship, the FIR that is on page 23. Kindly see the lordship date of FIR, lordship. 7/5/2026. On the same date, page 23, lordship is there.
Yes.
He was caught red-handed, lordship. At the time, it is say as per lordship FIR as 8:20 p.m. lordship. Material was seized from this present petitioner, lordship. That was, lordship, reflected in the seizure list also, lordship. That is on page 28, lordship. Can you see the lordship date and time of seizure? 7/5/2026 at 8:41 p.m. Page 28, lordship.
Yes.
On the right hand corner, lordship, this was seen on 9/5/2026, lordship. Now, lordship, kindly come to the forwarding report that is on page 42, lordship. Here, lordship, forwarding date is 9/5/2026. Though this person in the control of the police on 7/5/2026 at 8:41 p.m. lordship, but he was produced before the magistrate on 9/5/2026 lordship, beyond 24 hours, lordship.
No, Mr. Soduri,
Yes, lordship.
the time of apprehension may not be the time of arrest.
Lordship, he is under the control of this police, lordship, at the
Maybe.
time. Yes, lordship. He was under the control at
No,
that
no,
time.
maybe.
Yes, lordship.
Merely because he was taken to the police station, it does not mean that he was arrested. When he was formally arrested, then
As
what
per
is
F-
stated in the forwarding report?
Forwarding of forwarding report say, lordship.
You see, the time and place of arrest 8/5/2026 at 11 a.m.
11 a.m. Subsequently, they have shown this arrest, lordship, on 8/5/2026 at 11 p.m. lordship.
A.m.
AM, lordship. during that period, Lordship, he was not allowed to go, Lordship. He is not free from
Maybe.
that time, Lordship. He is
May-
under the control of the police, Lordship, investigation officer,
Mm.
Lordship. That is the Lordship.
You have been furnished with the memo of arrest?
Lordship. Memo of arrest, Lordship, I am not, it is in the TCR, Lordship, can you peruse that, Lordship? I have not, the client has not supplied me that copy, Lordship.
Your name is?
Sanindul Hawk. Sorry, Lordship, arrest memo is there, Lordship. Sorry, I'm apology, Lordship, beg apology. Page 34, Lordship. Arrest memo is there.
34.
34, Lordship.
So here also the date is
Yes,
8/5/2026.
But Lordship, he cannot move, Lordship. It's,
No, the question is when whether he was arrested at the time of his apprehension or not.
he was detained at that time, Lordship, on 7/5. In that
Maybe,
regard,
maybe.
in that regard, Lordship, I find the coordinate bench judgment, Lordship, in a similar
No,
situation.
coordinate
Yes.
bench forget about it.
Yes,
There is a
Lordship. There,
decision of
Lordship, reference has been
decision
made
of Supreme Court is there. That date of apprehension may not be the date of arrest.
our case covered by this one, Lordship. Here also, Lordship, the forwarding, he was detained and subsequently forwarded after 2 days later, Lordship.
Yes, Mr. Borthakur, perhaps it is in the case of DK Basu.
DK Basu.
The date of apprehension may not be the date of arrest. Can you find out the decision?
I have the purpose with me, my lord. Regarding his contention, my lord, I have also flagged my detailed GD entry. Everywhere is there when police, my lord, initial GD entry number 21, that is the, my lord, initial information. And here from the FIR, he pointed out, my lord, that is the GD entry number 21, that is 7/5/26. That is only the GD entry number, but FIR on 8/5/26, on the basis of GD entry, my lord, thereafter, my dear, on here's thereafter GDNT number 24. My lord.
GDNT 21.
Authorized letter by SP, my lord, by the SP, my lord. Thereafter, my lord, GDNT number 25, dated 8/5/26. At about, my lord, 12:28:35 AM, proceed as per GD number 21, OC along with, my lord, all other police personnel on 8/5/26. On 8/5, they all proceeded to the spot, my lord. Everything is there in the ZD.
8/5.
Thereafter, my lord, on 8/5/26. And thereafter, my lord, GDNT number 17 on 8/5/26. And when, my lord, he was produced for GDNT number 10/010, at about 1:30
No, Mr. Borthakur, that's all right. But can you show me the relevant observation made by the Supreme Court in this DK in the decision of DK Basu? That time of arrest may not be the time of apprehension.
Yes.
Find out the proposition. You go through it. We take it up at 2 o'clock.
Lordship, can it be some other day, Lordship?
Why?
Because that DK Basu I have to place, Lordship, regarding, Lordship, illegality of the arrest, Lordship. That
Okay.
And now, my lord, DK Basu, section 36 of the BNS, my lord, because after this, DK Basu, my lord, those guidelines, where my lord, only till any provision is made in this year, thereafter now provision is, my lord, section 36 BNS.
Now, 50 is the lordship statute said
No,
within
no,
24
that's all
hours.
right. My only concern is the date of apprehension may not be the date of arrest. That is. Art, Mr. Sodhuri, learned counsel for the accused, and Mr. Portakur, learned additional brief for the state respondent. Art in part, list the matter on tomorrow.
Next week, lordship, any day, lordship. Tomorrow.
20. Okay, 20. You take it back at DK Basu.
Yes, lordship.
This two decision on that day, you can produce it.
Yes.
I think 44, 45.
Yes, all the parties are ready to argue the matter.
Lordship.
Buddha is not there.
Lordship, he's coming, I think he.
I think he thought, I think he thought for the penalty down.
Okay.
Or Lordship, we can start Lordship as we can call Lordship. Yeah.
At 2.
Not Lordship, the Lordship.
My lord, on Friday, my lord, your lordship granted one bail in a CBI matter, my lord, where, my lord, it was directed that learned special judge CBI court number 1. Friday, my lord. Saturday, Sunday, there was holiday. Today morning, the bailer came from Tinsukia, and when we submitted the bail bond, my lord, we are told that you get it corrected at special judge CBI, not court number 1. My lord, I'm filing an IA.
On the other day, the standing counsel for the CBI
She
asked you to confirm it. It was your duty to confirm it and to apprise the court master that this should be the proper court. You failed to discharge your duty.
My lord, in that case, my lord, I am sorry, because, my lord, that CBI court
Let it be tomorrow.
My lord, can it be kindly taken up today, my lord, because
No, sorry. You have failed to discharge your duty.
Item number 44 and 45 to continue.
Yes.
Lordship. Lordship, in this case, Lordship, court is hard in the lands, Lordship. Lordship, just I would like to refreshment purposes, Lordship. I mentions Lordship that here, Lordship, this contempt petitions, Lordship, errors, Lordship, in judgment, Lordship. There is case 11, Lord. Page 11. Lordship, in direction space, Lordship, page 21. Lordship, before going to directions, Lordship, kindly see, Lordship, the finding. As because, Lordship, why I am submitting, Lordship, as because the presently against rejected, as whatever ground is taken, their finding already given in this adjustment, Lordship. So, Lordship, page number 16. Page number 16, paragraph number 7, Lordship. Lordship, may I read? It is to be noted that the teachers serving in various Bhansari schools whose services were not provincialized at the time of provincialization of their said school was denoted as a drop teachers, and thereafter, in term of the policy adopted by this government in these connections for provincializations of service of such teachers and published by an office memorandum dated 13/1/2023. The petitions claim the said benefit. The High Power Committee is constituted for the purposes of considering the case of the drop teachers, considering the case of the petitioner and rejected her case on the ground that the petitioner had joined her service in the said school after school came to be provincialized. The said decisions was communicated that the petitioner had order the Lordship. Ultimately, that order has been set aside, Lordship. Now, Lordship, kindly come to paragraph 10. Paragraph 10, Lordship, the first, in the earlier occasions, Lordship, if the first ground account as assigned by the High Power Committee toward the rejections of the case of the petitioners for provincialization of her service, that she being an additional teacher of the said school was not entitled for having her service provincialized in the fact and circumstance of the present case cannot be sustained. And not, Lordship, 11 is important, Lordship. 11 and 12. 11, Lordship, the appointment of the petitioner was so necessitated, Lordship, that is so necessitated on account of the fact that there was a necessity of a graduate teachers in the school, and the recognizing such necessity, the school managing committee had proceeded to appoint her as a teacher in the said school. The non-nomenclature as assigned to the petitioner on her such appointment of being an additional teacher is of no consequence in as much as the said designations given by the school managing committee when the said school was in a Bhansari stage cannot be held to mean that petitioner was an access teacher. Lordship, it is most important, not access teachers. Now, Lordship, second paragraph, paragraph number 12. A perusal of the materials brought on record does not reveal that the appointment of the petitioner in the said school was in excess of the requisite number of the teacher mandated to be appointed in the said school. Further, it is not the contentions of either the High Power Committee and or the respondent authority that the petitioner's appointment as effected on 4/2/1996 was in excess of the required number of the teachers mandated to the available in the said school. Now, Lordship, next paragraph of Lordship, it's saying that the petitioner could not have been denoted to be an additional teacher, as also on the ground that the authorities, while provincializing the service of the serving teacher in the said school, had only sanctioned a limited number of this post of this teachers. For the effecting such provincialization, it is to meet such situations where there are more number of teachers working in the said in the school than the number of post sanctions, and that the government had adopted a policy as available in the office memorandum dated 13/1/2023, and accordingly the rejection of this case of the petitioner on the ground found that she was an additional teacher of the said school is clearly perverse. Therefore, it cannot be accepted. Lordship, this is the finding, Lordship, that he is paragraph number 11 and 12. It categorically mentions the present petitioner's appointment was so much necessitated. And that's why, Lordship, and moreover, she was not an access teacher. And that's why, Lordship, when an access, there is a drop teacher, then there is a policy of this state government. So that's why that policy is governed in the case of drop teachers. So in this regard, Lordship, the direction has been given. Lordship, direction is page 21, paragraph number 20. In view of the fact that the order dated at 18/1/2021 has been interpreted by this court on arriving at a conclusions that the grounds as assigned for for rejections the case of the petitioner herein are clearly not sustainable. The matter now stand remanded back to the Director Elementary Education Department, Assam, who would now place the case of the petitioner again before the High Court Committee and or any other committee presently in existence for the considering the case of the petitioner for provincializations in accordance with the decisions of this court rendered in provincializations regularization service of the drop teachers as well as the policy as contained in the office memorandum dated 13/1/2023. Now, Lordship, next paragraph number 21. The High Court Committee shall strictly, Lordship, shall strictly consider the case of the petitioner in term of the said office memorandum dated 13/1/2023 and the decisions of the rendered in the case of Tafan Chandra Das. And next, Lordship, in the event the High Court Committee recommends the name of the petitioners for provincializations of her service on considerations of her case strictly by appreciating the factual positions available with regard to the service rendered by the petitioner in the said school, such as provincialization shall be effected with effect from the date. The other similarly situated drop teachers came to be regularized in their service in pursuant to office memorandum dated 13/1/2003, Lordship. So, Lordship, here in this case, Lordship, so direction ultimately, Lordship, as per this.
Mr. Hawk, here the direction was to consider direction was to the High Power Committee.
Consider
strictly consider the case of the petitioner in terms of the office memorandum dated 13/1/2003.
as well as the one
and the
judgment, Lordship.
decision of the
Tapan Kumar judgment, Lordship.
yes.
So, Lordship, here
Where is the decision of the Tapan Chandra
Lord,
Das?
it also annexed in my original writ petitions. It also annexed, Lordship. So, Lordship.
Original writ petition. Original writ petition.
Lordship, kindly consider one thing,
Yes.
one thing, Lordship. Here, paragraph number 11 and 12, it is mentions, Lordship, court is came into finding the present petitioner is not a access teacher, and her appointment wasn't so necessitated. That's why she was appointed, Lordship. So whatever name has been given as an additional teacher, that will not be affected. This is the finding of this court, Lordship. So, Lordship, thereafter, what happened, Lordship? Kindly see this, their affidavit, Lordship, their first affidavit, Lordship, that is page, Lordship, 26. Started, Lordship. In this case, Lordship, the the High Court Committee rejected my claim, the present petitioner, showing that, Lordship, that she was not continued, Lordship, 2-year service, as because there is in that notifications there is a condition is there. So, Lordship, in page 46, Lordship, that 46 and last paragraph, Lordship, decision. After careful examinations of the case and officials' records of the committee found that the petitioner Maloti Bepari was appointed in 1996 by the managing committee, school managing committee without undertaking due officials and established rule. The committee found that the school had already been provincialized in 1980. Based on Assam Elementary Education and Provincialization Rule 1977, the committee also found that the petitioner Maloti Bepari does not fulfill the clause of Assam Elementary Education Provincialization Rule 1977, and therefore her claim cannot be considered and is rejected in as much as Maloti Bepari in term of Rule 5.3 of this Assam Elementary Education and Provincialization Rule 1977 had not completed 2 years of the continuous service immediately preceding the taking over the school in 1988. So, in this, Lordship, thereafter, Lordship, I have filed an affidavit as because same ground has been taken earlier, and that ground has been rejected by this honorable court. that ground already set aside. So Lordship, kindly see my next, my affidavit that is started, Lordship, page 70. In 70, Lordship, I have annexed the earlier rejection order and as well as the High Court finding, High Court's order, Lordship. In this High Court orders, it also came into conclusions, Lordship, to know when the petitioners was appointed, that school was is revert back his original status, that is a Bhansari school. So managing committee can appoint, Lordship. So ultimately, Lordship, that order I have challenged by the next item, Lordship. But in the meantime, Lordship, they withdraw this order, Lordship. In so modo, Lordship, they are realizing that order earlier has been taken a stand, and that stand has been set aside by the High Court. So they submit before this honorable court. They are fresh thinking, Lordship. So ultimately, Lordship, they are thinking fresh. Again, Lordship, taken a second decisions. There is his page, Lordship, 88, Lordship. That affidavit, Lordship. In their affidavit, Lordship, they have again rejected. It is now showing the another ground. Whatever ground has been taken, Lordship, in now that finding already given in paragraph number 11 and 12 of this writ petitions, Lordship. So in their hyper committee's second opinion, Lordship, opinion, kindly see, Lordship, is started page 116. Lordship. Lordship, here in this hyper committee, Lordship, just I would like to mention, Lordship, that they have sought for report from the DEO or BO, Lordship. And in this report, Lordship, it is mentions the teacher's patterns and Lordship, relevant paragraph, Lordship, kindly come into page 119. There now, Lordship, they are taking a different stand. Now, Lordship, they are saying, Lordship, that Lordship, as per this notifications, their students ratio should be there. So they are saying, Lordship, no, their ratio was not there. So, Lordship, kindly see paragraph number 119 in the last paragraph, Lordship, serial number B. Lordship, here it is a 1996 table has been given, Lordship. 1996, the students, number of students, Lordship, it is 51. In the year 1996, the peasant petitioners was appointed, Lordship. And in the year 2008, Lordship, 8 has been given, Lordship. In the right side, Lordship, it is showing, Lordship, 86. 86. So, Lordship, then now, Lordship, kindly come to the next page. Lordship, next page, the Lordship, here it showing in Lordship is a column number C. Column number C, Lordship. Here it is showing what is saying, Lordship. There is, Lordship, in earlier, Lordship, in this report is reflected, Lordship, teacher pattern. As a science teacher is mandatory. And here it is showing, Lordship, there's one science teacher as well as the, Lordship, the Hindi teachers, still that post is not sanctioned. Lordship. And Lordship, ultimately the finding, Lordship, kindly come into last page. Last page, Lordship, page is 121. Lordship, in its decisions, the committee has thoroughly examined the report of the DEE Assam, and it is observed that although the petitioner is found to have been rendering continuous service in the school for 2 years, immediately he proceeding taken over her by GOVT, given him the fact that the school was provincialized in 2008. However, appointment of the petitioner by the managing committee does not commensurate with the enrollment of the student in the in the school at the time of provincializations. The petitioner was as appointed as an additional teachers, and she was not promoted to the post of assistant teachers. Considering the low enrollment in the school at the time, no additional post was required to be created, Lordship. So, Lordship, this finding, Lordship, he directly hit the finding of this Honorable High Court's paragraph number 11 and 12. Paragraph number 11 and 12, Lordship, is very much our Lordship. If this is a present petitioner is not an excess teacher, her appointment was so necessitated, Lordship. So this finding, Lordship, directly heated, Lordship. Now, Lordship, in this against this, Lordship, is hyper committee's rejections, Lordship. I have filed an additional affidavit, Lordship. Though, Lordship, I just referring this affidavit as because, Lordship, though their finding is not sustainable, as because against their finding, this court has already given finding. Whatever issue has been raised, that issue against that issue, this Honorable High Court in paragraph number 11 and 12 already given finding, Lordship, and that order they did not challenge. Is still not challenged, not reviewed, that it is admitted, Lordship. So once admitted, one finding is admitted, then same finding they cannot reject it in subsequently on the same ground. Whatever ground has been this Honorable Court has been given finding, Lordship. So, Lordship, now kindly see my affidavit 123 page number. Here, Lordship, what happened in this case? I have annexed my attendance, Lordship. The students' attendance, Lordship. In this student attendance, Lordship, it is I have collected.
Mr. Hawk, you see, this is a contempt petition.
Lordship.
Can we go into the facts again here?
Yes. Lordship, just I'm referring refresh purpose. Why? Lordship, they have submitted one instruction. In their instruction,
You see, the direction of this court was to consider the case again.
Okay.
It was considered.
Yes.
And it was rejected.
Lordship, my submission is very limited, Lordship. When they now taken a step, the present petitioners was excess teachers. They're saying that student ratio was low. Lordship, for a time being, can we see the legal provisions? How many students is required? And what students was there? The loss.
Again, the question will come. Can we go into the facts here?
Lordship, I understand, Lordship. I am referring just refreshment purpose.
Yeah, we have to see what was the direction of this court and how it has been implemented or not implemented.
Lordship, kindly see the notifications, Lordship. Whatever court directed pursuant to the notifications. Lordship, kindly see the notifications, Lordship.
Page number?
Lordship, 49, Lordship.
Page number 49 is the affidavit
No, Lordship,
of the director.
item number in disposed for this. No. Page 49. 49. 40.
Yes.
Lordship, this is the notifications, Lordship. Here, Lordship, there is conditions, Lordship. Whatever first conditions, the Lordship, the teacher must have put in at least 2 years of the continuous service immediately proceeding in the taking over the concerned school by the government. It is, Lordship, this point has been there. Now they are admitted, Lordship. Now, Lordship, the second point, Lordship, the appointment of drop teachers must have already approved by the concerned DEO, inspector of school. Lordship, that is also approved letter is there, Lordship. That is also approved in the year 2003. And now Lordship kindly the third condition. The appointment of the drop teachers by the managing committee must be commensurate with the enrollment of the student in the schools at the time of provision. Lordship, that point they are taking now stand is taken, Lordship, in this point, Lordship. Lordship, in this case, Lordship, the Honorable High Court, this High Court already given finding that I am not an access teachers. Why, Lordship, just I would like to mention, so Lordship, why this court came into finding that I am not a access teachers? As because there is an instruction is there, Lordship. At that time when this repetition of Lordship was there is an instructions. In this instructions, Lordship, is available in the record. In the I think Lordship is after order sheet. It is marked as a X, Lordship. In that instructions, Lordship, it is mentions the peasant there was a post was vacant. As because, Lordship, that there is a science teacher was there. Science teachers was appointed in my place, Lordship, as assistant teachers subsequently. So that's why, Lordship, department has created problem, Lordship. So that's why court is came into finding, peasant petitioner is not an access teachers. Lordship, if Lordship their stand is now taken is correct, then what will be, Lordship, the finding of this High Court, paragraph number 1, 11 and 12? What will be there, Lordship? Paragraph number 11 and 12. If their stand is taken and considered is correct, then Lordship, the finding of this Honorable High Courts, then we will go through it, that finding, paragraph number 11 and 12. Paragraph number 11 and 12, it is clearly stated, Lordship, that the peasant petitioner is not an access teacher. Her appointment was so necessitated. So that's why so she was not access teachers. Now, Lordship, they are taking this stand. They are peasant petitioner is access teachers. They cannot take in, Lordship. As because in contempt, Lordship, in contempt cases, Lordship, whatever the point has been raised, that finding already given. It is, Lordship, so far my understanding, Lordship, it is clearly, Lordship, willful disobedience of the order, Lordship. As because, and moreover, one thing, Lordship, this is the seventh number of seventh round litigation.
You tell me whether they are not bound to follow this notification, which you have referred to at page
No, Lordship.
number...
No, Lordship, my submission is limited, Lordship. I am referring whatever, Lordship, it is just refreshment purposes, Lordship. I am submitting, Lordship, this once this code is came into finding that peasant petitioner is not an access teacher. Now they cannot take in that stand. The peasant petitioner is an access teacher.
You answer my question. Are they not bound to follow this notification? Page number 49.
Lordship. Sorry, Lordship.
Are they not bound to follow this notification?
Lordship, they have to bound, Lordship.
They have to.
Bound. As
And they have followed it. They have followed it.
Followed it.
So what wrong with this?
Lordship, whatever that stand has been taken, whatever the ground has been taken, that grounds already resolved by this order. Paragraph number 20, 11 and 12, it is saying that peasant petitioner is not access teacher. His appointment was so necessitated. On the basis of necessity, the peasant petitioner was appointed and he was not an access teacher. So if this is correct, if they admitted as because they did not challenge this finding, now they cannot take the stand that peasant petitioner is access teacher.
The question is whether that was the issue before this court.
Lordship.
In that petition. The observation made by this court in respect of paragraph number 11 and 12, whether that was the issue before the court,
Lordship,
or it was a casual observation.
No, Lordship, Lordship, what happened, Lordship? This court has been given came into finding, a given observation from all the point. Yes, because they...
No, all the points that all right. But whether that was the issue before the court.
Lordship, one of the ground, Lordship. Yes, because they're saying, Lordship, the peasant petitioners was appointed as an additional teacher. As an additional teacher, and there is no post, or there is not required as an additional post. So that's why, so Lordship, it is also a issue, Lordship. So far my understanding, as because, Lordship, they taken a stand, the peasant petitioners was a additional teachers. and there is no post or not required additional post. So that's why, that means indirectly, Lordship, it is came into access teachers.
Okay.
The original order.
Mm.
Page number 103, Lordship. In my 217. There are 20 and 22. I'm sticking to only to this one.
Page number?
My epidemic is 270.
270.
70. Number.
270 is the order.
Order.
Yes.
Order. There are 21 and 22. I'm just reading.
You have put a container number 4.
Yes, I'm just newly updated.
Okay.
Lordship, I am referring to this, para number 21. The High Court Committee shall strictly consider the case of the petitioner in terms of the state office member and the decision of the court rendered in the case of Tapans under the para number 22. In the event, the High Court Committee recommends the name of the petitioner for provincialization of her service, consideration of her case strictly by appreciating the factual position available with regard to the services rendered by the petitioner in the state school. Such provincialization shall be effected with effect from the date other similarly situated job seekers came to be regularized in their services in person of the office memorandum dated so. Lordship, my only limited understanding, Lordship, here the honorable court, while passing the order, has not come to the conclusion that he is legally bound. They have referred the case to the High Court Committee. Even not a single observation, an observation made by in earlier part of the order, it being superseded by this Lordship. The High Court Committee named services continuing specifically appreciating the factual position. So the honorable court, while delegating to the High Court to strictly appreciate the case of the petitioner in terms of the office memorandum and the Sopal. In that case, all those references or observations made in the earlier part of this are already gone. It's still superseded. It has been delegated to the High Court Committee, and High Court Committee has already given a come to that conclusion, Lordship, rightly or wrongly. In that case, Lordship, if he has a problem, Lordship, with this order, Lordship, he has the opinion, he has the liberty to file an appeal, Lordship, to file a writ petition against this High Court Committee.
No, that writ petition is pending.
No.
No.
he has not filed it.
No.
The petition which is connected to petition.
Yes.
This is with regard to the decision that was taken by the High Court Committee before the decision now on record.
Okay.
Happened, if I may clarify.
Mm.
After the decision that was taken, this contempt petition was simply we produce the minutes of a High Court Committee.
Mm.
This honorable court found that the High Court Committee had not given its consideration in terms of the direction as it is.
Mm.
Because the direction is very specific. That we will have to freshly consider in terms of the office member.
Mm.
That part was missing. And therefore, my lord, this honorable court gave us last chance to comply with the order. Accordingly, my lord, this again a fresh consideration was given.
Mm.
In terms of the office memorandum, a report was called from the Director of Elementary Education. Once the High Court Committee will have to rely on the factual report from the administrative department.
Mm.
Therefore, a report was called for. And based on the report, the High Court Committee gave a consideration, and the committee refused to recommend him for provincialization.
Mm.
Now, all of the direction was for consideration in terms of that office memorandum. And the report which was called from the director was only 5 points that is mentioned in the office memorandum.
Mm.
Out of that 5 points, there were 2 points where the report came in negative, and therefore it was not considered.
Mm. Okay.
That how we are respectfully submitting the direction of this honorable court as this was newly complied. Now, what my letter saying excess teacher, the Lordship has very directly pointed out that question to him, my lord, that was that an issue? And that issue was decided, and accordingly the earlier recommendation, earlier rejection was satisfactory.
Lordship, just one point.
No, please, let him complete.
Lordship.
But in this case, Lordship, my limited understanding is that, Lordship, all the observation made in the prior to para 20, observation is being superseded by the para 22, Lordship. Para 22. Because here, Lordship, the Honorable Court, while passing that order, for which the contempt has been done, here already delegated already directed us, the High Power Committee, petitioner for her services on consideration of her case strictly in by appreciating the factual position available with regard to the services rendered by the petitioner. In that case, Lordship, my understanding is that the Honorable Court was never has not given any opinion regarding the status of the petition contempt order, Lordship. In my understanding, also. Because that is not because all is being referred to the High Power Committee, and High Power Committee, rightly or wrongly, maybe rightly, maybe whatever it is. They have the opportunity, they have the liberty to go for an edit petition to challenging that order. That can be rectified in that way, Lordship. In my understanding, Lordship, in contempt case, we have fully cooperated with fully complied with the order passed by the Honorable Court. That is my side. Limited submission, Lordship. But Vedanto will say something.
Here for the newly implemented respondent number 5. He is the Joint Secretary of the Finance Department, and he was a member of the High Power Committee. So with due my lord, respect to the majesty of this Honorable Court, I humbly submitted, my lord, there is no contempt in this present case, my lord, at least by this High Power Committee members, my lord. Because, my lord, there was a direction passed by this Honorable Court that, my lord, the case of the petitioner should be reconsidered in adherence of the, my lord, OMZ 2003. Now, a decision was taken and the leaking order was placed before this Honorable Court. After considering that, my lord, the Honorable Court passed an order. It is dated, my lord, 24/9/2025. Possibly will find that at page 231 of the affidavit, running page 231 of the affidavit filed by respondent number 5.
Two
231. Lordship, it is an order dated 24/9/2025. Lordship will see, my lord, the fourth para. I have carefully gone through the additional affidavit filed by the petitioner and orders of this Honorable Court dated passed in WPC so and so, and also produced the order dated 15/12/2015, annexure M of WPC so and so, and the compliance of order of the minutes of the High Power Committee meeting dated 12/3/2025. Now, Lordship will come to the, my lord, last part at page 233. Lordship found that, my lord, it is contemptuous. So, my lord, last para, Lordship will see 233. Under such circumstances, this court deems it appropriate to grant last opportunity to comply with the order of the Honorable Court, and accordingly it is provided that the respondent and contemptor shall produce the compliance order before this court on 15/10/2025. After this order was passed, my lord, the earlier order of minutes, my lord, that is 12/3/2025. This was, my lord, withdrawn, or say it was cancelled. And, my lord, they had gone for a, my lord, press, my lord, consideration of the petitioner's case pursuant to the earlier order passed by the Honorable. That meeting, Lordship will find at page 234. It is 24/10/2025. Here, my lord, after considering, I'm sorry, my lord. Yes. Lordship will find it at page number, my lord, 234, 235, the decision. Lordship will see contempt case number is also mentioned. 234 decision, Lordship will see. After careful examination of the matter, the committee found that the concerned directorate is to inform
with a detailed report if the petitioner fulfills all the criteria laid down in the OM dated 13/1/2003. The High Court Committee requested Director Elementary to elaborately examine the following points and submit the report at the earliest. If the school was in effect provincialized in 2008, did the petitioner put in at least 2 years of continuous service immediately preceding the taking over by the government? First query. Second, was the appointment of the petitioner by the managing committee commensurate with the enrollment of the students in the school at the time of provincialization? Was the school-wise norms of number of sanction posts maintained? For provincialization particulars submitted by DEO, IS and available with the directorate will be used as a reference. The same remains to be shared with the director. Regulation of service will be subject to availability of sanction posts in the concerned district. Now, Lordship will see the poem. Just whether these queries were correct or not. This query has been raised during the pendency of the contempt petition. Lordship will see page 112 of one of the affidavit filed by the Education Department. 112 is the running page.
Yes.
Here, my lord, it is a OM dated 13 January 2003. Now, Lordship will see serial number 3, 4, and 6. May I read those 3 points? The appointment of drop teacher by the managing committee must be commensurate with the enrollment of the students in the school at the time of provincialization. This was the query raised pursuant to the OM of 2003. Next, my lord, serial number 4. The school-wise norms of number of sanction posts to be maintained. This is one of the query of the minors that I have just now placed. And number 6. Teachers fulfill the above criteria will be considered for regularization of the service subject to the availability of sanction post in the concerned district. These were the queries put forth by the committee again, for reconsidering the case of the petition aforesaid. And this director, the Directorate of Elementary Education has finally submitted the report at page 240 of the affidavit filed by respondent number 5. 240. After elaborating the facts, page 241, Lordship will see the reply to the first query. Lordship has seen the bold letters, page 241. It has been highlighted by A, small a, after the chart, and this para 7, page after para, page 241.
Yes.
If the school was in effect provincialized in 2008, did the petitioner put in at least 2 years of continuous service immediately preceding the taking over by the government? The reply from the director was, from the records of the attendance register maintained by headmaster on 27/10/2025 in the office of the DE Assam, it is found that the petitioner is found to have been rendering continuous service in the school for 2 years immediately preceding the taking over of the government, given the effect of the school was provincialized in 2008. In this connection, it is stated the service of the teachers were temporarily approved by the DEO by order dated 6/10/2004, which were provincialized based on the numbers of post sanction as mentioned in point number 5 in the year 2008, and their services were regularized from the date of appointment by SMC. So this point was in favor of the petitioner. Now, Lordship will see the second query. For the appointment of the petitioner by the managing committee commensurate with the enrollment of the students in the school at the time of provincialization. The reply is, well, as per UDI's report received from the SSA Assam, the enrollment position of the school of the petitioner for the year 2008, that is at the time of provincialization, was 92. In this connection, it is stated that as per minutes of the state level committee, for considering the permission, recognition and upgradation, concurrence of educational institutions held on 2/4/2005, minimum enrollment in one class would be 30. And if there are more than 55 enrollment in a particular class, the school may open a new section with prior approval of the DE after fulfillment of necessary conditions. In the instant case, the class-wise enrollment as furnished by DEO accommodation for the year 1996 and 1996 to 2008 is given in the next page. Now, the finding, my lord. So the school was not eligible for opening of the new section and also appointment of additional teacher even at the time of appointment of the petitioner, that is Maloti Bepari, during 1996. Also, the enrollment of the school did not permit to provincialize additional teacher during 2008. Further, there was no record of sending any proposal for approval of additional teacher received from the DEO Dhubri. The appointment of the petitioner by the managing committee does not commensurate with the enrollment of the students in the school at the time of provincialization. Also, the appointment of the petitioner was not done following existing rules, and the appointment cannot be considered for benefit of interest of students. Instead, benefit of petitioner only. This was the report regarding the second query. Now, Lordship, the third one. Was the school-wise norms of number of sanction posts maintained? The petitioner was appointed as additional teacher and she was not the science teacher of the school, nor was she promoted to the post of assistant teacher. The staff pattern of ME school, ME Madrasa has been stated in point number 2. Total 05 posts of teachers, that is 5 posts of teachers were sanctioned during provincialization of the school of the petitioner in 1980. As per details stated in point number 1. Accordingly, posts of existing teachers were provincialized. Thereafter, DEO Dhubri submitted proposal for sanction of 2 posts, one for science teacher and another for Hindi teacher, to fulfill the minimum requirement of the staffing pattern as per government norms. DE Assam submitted proposal to the government for sanction of Hindi teacher in respect of Navanita Mandal, who was working as Hindi teacher in the school since 1990. But instead of creating Hindi post for the service of Nandita Mandal, Hindi post was Navanita Mandal was regularized against a sanction vacant post of Hindi teacher in the district in pursuant of government approval by office order dated so and so. The post of science teacher is not yet created against the school. The school-wise norms of number of sanction posts of the assistant teacher is already maintained in the school as 2 numbers of assistant teacher are already created and the services of existing teachers are provisional. So there is a vacancy against the said post. Hence, no additional post is required to be created in the school for assistant teacher considering the low enrollment in the school. So this goes against the petitioner again. D. Provincialization particulars submitted by the DO available at the student is the particulars. Now, in the next page, regulation of service will be subject to availability of sanction post in concerned district. It is yet to be known if there is such availability of sanction post is in the concerned district. There is no available sanction post in the district for regularization of service of the petitioner. My lord, pursuant to the OM, my lord, it was reconsidered. Now, my lord, they are a party in the condemned petition, my lord. Despite that, my lord, they have reconsidered, and why will they dare to violate the honorable court's order again in when they are a party in the condemned proceeding? There is an order of this honorable court. They have to comply that. For violation of that, there will be contempt. Here they have again, my lord, reconsidered. Raised certain specific queries as part of OM of 2003. Then this final decision was taken again. That decision. That decision, my lord, is now on record. During the pendency, they have revisited and they have reiterated their decision that, my lord, he sees or he is not entitled for this.
No, is it permissible to revisit the matter while the matter is sub judice before the court?
My lord, that this honorable court has given last chance. That's why I read the last chance.
Oh, compliance. Last chance for
Yes.
compliance.
Under such circumstances, this court deems it appropriate to grant last opportunity to comply with the order of the honorable court. No, Lordship has not directed that you comply by provincializing the service of the petitioner. Lordship has directed that you have to comply pursuant to the directions passed by the legislative judge in the petition referred by the present petitioner, which is held to be, my lord, to be contempt, my lord, by the authorities. So, my lord, why will they dare to, my lord, violate it again? Because this on factual aspect, my lord, they have found that he is not entitled. Therefore, for the second time, my lord, in this proceeding itself, in the petition order, they have to, my lord, go for that final decision that he is not entitled. Otherwise, my lord, by on fear of the contempt case, anyone would have just provincialized her. But, my lord, they have rightly done, my lord. They have verified it. They raised certain queries as part of 2003. And, my lord, finally, this has been placed by the honorable court.
Now, my lord, can my lord, this honorable court in the contempt proceeding, my lord, with due regard to the my lord magistrate of the honorable court, my humble submission will be, my lord, whether there can be a mandamus now, considering the
No,
factual.
no. In contempt petition, where is the question of issuing
That's
mandamus?
why, my lord, now, my lord, only, my lord, opportunity the petitioner has is that, my lord, to challenge the fresh decision that has been placed. Minutely, my lord, they have verified it. In following, my lord, 2003 OM, my lord, he has every liberty to challenge the same. Well, he has beautifully argued, my lord, on the factual part today. But, my lord, whether in the contempt proceeding, those factual parts aspects can be, my lord, revisited in a contempt proceeding. That's the one, my lord, order which has been passed in compliance of the direction of this honorable court. This is not the proper, my lord, petition or, my lord, forum, my lord, as on date to challenge this. You have to prefer this petition. It can raise every factual aspect. It can appreciate, my lord, only, my lord, by the particular, my lord, bench when the appropriate petition is filed. Not in this, my lord, contempt petition. With due respect, my lord, I am submitting. Otherwise, they would not have, my lord. When an opportunity has been given, my lord, rarely we find it. But this honorable court has, my lord, given an opportunity, the last opportunity, you revisit it. They revisited it and they came to the same conclusion that he is not entitled. Why is they dare to, my lord? Apparently, my lord. Here is not the case that, my lord, access to be provincialized instead of the petition. Yes, only her claim that she should be provincial. Not to benefit someone that, my lord, they have rejected her claim. Apparently, under the 2003 OM, she is not entitled. That is their decision. And that can be again tested, my lord, provided she prefers the petition, challenging the same. That is my humble submission, my lord. And, my lord, in the affidavit, my lord, in all the paras, my lord, the entire sequence of event has been, my lord, beautifully, my lord, we have placed it, my lord, elaborately in this affidavit, my lord, how the sequence of events has happened. And finally, this is the teacher. And, my lord, there is no such willful violation or deliberate violation, my lord, to the father's portfolio. He is a member, my lord. Finally, the decision was taken, and she is being a part of the committee, my lord, that she has signed the, my lord, committee decision. Following whatever is there on record before the committee on the day when the decision was taken. For the second time. So that liberty is always there to the petitioner. He cannot, my lord, argue on factual aspect to justify the she is entitled for provincialization in this contempt proceeding, my lord. Because all she has accused.
Okay. So you have already.
Yes, but I'll just yeah. Since my friend has already taken your lordship to all the documents, I may not have to add many other things. But I'm representing the director and the secretary, as well as the secretary who happens to be the member secretary of the committee also. Now, there were one direction to the director is to place it before the hyper committee. But the director having done so, he has very respectfully complied with the order. And the other direction at paragraph 21 was, my lord, to the hyper committee where I am one of the member secretary, my lord. And if your lordship, just first line of the minus, my lord, of the hyper committee, my lord, page 116, your lordship will find that the member secretary, page 116, your lordship find it. Yes, sir.
Yes.
After the director has placed it before the hyper committee member, this is the fresh decision taken by the hyper committee 7/11/2025.
Yes.
But my lord will kindly come to the second paragraph. The chairman and the other members of the committee were briefed by the member secretary in respect of the case to be placed before the committee for examination. But since the other committee members were not before your lordship in the contempt proceeding earlier, it was only the member secretary who was pleaded as respond number 1. And the earlier minus upon being placed before this honorable court expresses dissatisfaction to them and has given a liberty to comply with the direction. And that direction was to strictly comply with the office memorandum of 2003. Now, The committee, my lord, page 117, my lord, finds. First line, my lord. That is in compliance of the Honorable High Court's order dated 24/9/2025 in contempt case number so and so, the matter was looked into afresh in the meeting dated 24/10/2025. So the member secretary being one of the party in the contempt proceeding when this 24/9/2025 order was passed, my lord, he briefed the committee members that a fresh decision has to be taken in terms of the office memorandum dated 13/1/2003. And accordingly, the committee unanimously, my lord, has called for a report from the director in terms of all the criteria that is to be followed as per the office memorandum of 13/1/2003. And based on that, my lord, after considering that report of the director, my lord, the committee has decided that the petitioner, my lord, is not entitled for provincialization. And thereafter, in persons to this minutes of the Hyper Committee, page 122 is the speaking order passed by the secretary. The point number 1 in its capacity of secretary of school education, rejecting the claim of the petitioner.
Okay. Yes, what is your reply?
The secretary, the responsible 1, 2, and 3 has duly complied with the order. With all respect, they have the respect towards this court's direction.
Yes.
Paragraph 21 was the only direction, for consideration. There was no positive direction for provincializing the service. Once the consideration has been given in my respectful submission, the order has been duly complied with. Now, if the petitioner is aggrieved by the consideration, there is no, in my respectful submission, while complying with this order, all the measures which has to be taken for in the decision making process has been adopted.
Okay.
Lordship, whatever my learned friend is submitting, Lordship, just one thing, Lordship, I think is not completely correct. Lordship, Lordship, in the during the contempt proceeding, in the first time they are rejected, the ground is showing whatever ground is taken, that ground already set aside, already taken in the year 2015 by the same High Power Committee, and that ground already set aside by this Honorable Court. So that's why, Lordship, they when it bring into notice before this Honorable Court, then Lordship, the last chance has been given. So comply. So Lordship, in this compliance, in the subsequent rejection, whatever decision has been taken, Lordship, if these decisions, Lordship, if they, Lordship, if whatever ground stand has been taken, now the student ratio is not there. Lordship, that against that, that means present petitioner is an excess teachers, Lordship. So once other excess teachers, Lordship, the question will come that issue already given, already resolved by this Honorable Court. That present petitioner is not an excess teachers. So question will come, Lordship, whether a issue has been resolved by this Honorable Court, can they taken the same issue? Lordship, that is the important part, Lordship. Lordship, my submission is that, Lordship, the High Power Committee, Lordship, they did not consider, the considered, Lordship, meaningful considerations, actual considerations, that has not been taken. As because, Lordship, this finding, paragraph number 11 and 12, that against that finding, they did not challenge, Lordship. They did not review. So once they did not challenge or review, so the Lordship, they has to be admitted, Lordship, or they has to be obey this order, Lordship. So their ground, Lordship, whatever taken, my limited submissions, Lordship, that it is a wrong, it is a deliberate violation, Lordship, as because Lordship earlier occasions during this contempt petitions, earlier occasions they are taken as one stand, which is taken in the year 2025, or already set aside by this honorable court. But it is impliedly, Lordship, it is clearly indicated their intentions, Lordship. Their intention is very much clear, Lordship. Their intention is that, Lordship, that now whatever decision is taken, it's not, Lordship, sustainable in law, as because, Lordship, if suppose, Lordship, we have going to challenge this order, suppose assume, Lordship, we have going to challenge this order, court will be said, then no, your issue, that issue already, decision already given, paragraph number 11 and 12. What type of decision you require? So my submission is, Lordship, they did not follow this, Lordship, this office memorandum, as because, Lordship, this code is already, a finding has been given. That finding they cannot overlook, Lordship. So my submissions, Lordship, they deliberately violated this court directions, Lordships. And, Lordship, it's considerations meanings, Lordship, it's actual considerations or meaningful considerations, Lordship. And whatever their considerations they are going to consider, and whatever ground has been taken, that ground already, against that ground, the honorable court has been given given finding, Lordship. They cannot overlook, Lordships. So my humble submissions, Lordship, considering that all the aspect that present continuous, Lordship, they are deliberately violation.
But my left hand is pressing upon the excess teacher law. But here the issue was whether the benefit of provisionalization should be given to the petitioner under the office memorandum of 2003 or not. It is not that whether the petitioner is an excess teacher or not an excess teacher. Now, whether this honorable court directed to examine and to consider whether the benefit of provisionalization can be given or not. That's what, my lord, the issue was. And the paragraph 11, that finding that he is not an excess teacher, that culminated into a decision in paragraph 19, setting aside the wrong decision. That's
Lordship, just one point, Lordship. Whatever point is raising my friend, Lordship, that meanings, its meaning shows, Lordship. They are saying, Lordship, that present petitioners, as per the enrollment ratio was low, so her case was not considerable. Lordship, that meanings is that I am the if student ratio is low, that means I am the excess teachers. Either whatever number is required, that is more than. And one more thing, Lordship, in this hyper committee's report, one thing has been mentioned, Lordship, that the if opening in sections, it's required 55 number of students. Lordship, that will not be applicable in my case. Why? In my case, I am claiming the regularization in 1977 rules, not subsequent, Lordship. So at that time, the 55 number was not there. Lordship, they have mentions in their hyper committee, Lordship, the 55 number students is as required as per their Lordship meetings, Lordship. In that meeting in this Lordship 2005 as well as 2025, Lordship. 2005 and 25, Lordship. So my case is not.
No, whether your case was not considered under the 1977 rule.
Yes, my case will be considered 1977 rule, not present. I am not. Whatever
under which rule your case is considered by them now?
Lordship.
Under which rule your case is considered by
now, Lordship, they are taking the stand. One paragraph, Lordship. They're saying that 55 number students is required for opening a section.
No, where it is provided.
Lordship, they say, Lordship, can you see, Lordship? Lordship, that page and 119. And Lordship, there is exact line, Lordship, I am point out. As per minute of the state level committee for considering the permissions, regularized recognizations, upgradations, concurrence of educational institutions held on 2/4/2005. The minimum enrollment is one class should be 30, and if there are more than 55 student enrollment in a particular class, the school may open a new section. So, Your Honor, here it is a 2005. No, I am appointing, and this school was provincialized in the 1980.
No, you tell me, in which role this requirement is provided?
Lordship, they're saying, Lordship, as per their stand.
Mm.
Their stand page 119.
Mm.
They're saying, Lordship, in the year 2025.
No, whether
2005.
they have referred to any rule.
No, yes, Lordship. As per minute of the state level committee, they say state level committee. So in my case, that what if suppose assuming Lordship, that rule is that committee's decision is there, but that decision is not be applicable in my present case, Lordship. As because my present petitioner was appointed in the 1996. All the teaching and non-teaching staff, Lordship, after 80, all the teaching and non-teaching staff was appointed, Lordship. Initially, that school was provincialized in the 1980, Lordship. And after few months, that school was captain against as that regularization order. And that captain against order was vacated in the year 2008. During the 28 years, Lordship, during 28 years, as that all the teaching and non-teaching staff was appointed, including the present petitioner. All the teaching and non-teaching staffs, they are getting their benefit from the date of appointment, except present petitioners. They are showing earlier showing one ground, that ground already set aside. Subsequently taken another ground, that also ground, Lordship, set aside. So my submission is that, Lordship, whatever, Lordship, the stand has been taken, the low enrollment ratio, that is not applicable in my present case, as because the present this finding has been given as considering all the aspect as well as, Lordship, they have already submitted instruction, that instruction already on record, Lordship. On the basis of all the record instructions, this court came into finding that present petitioner is not an access teacher. So that's why, Lordship, that finding.
Okay.
Lordship.
Heard. Mr. Hawk, Learned Counsel for the petitioner. Mr. Kosik.
I have placed two judgments, my lord. I marked the paragraph under your lordship can go through it.
Okay.
Only on the point, my lord, the adjudication which he is asking for on merit. So that purpose is not permissible.
Lordship, though I have not gone through the judgment, but so far my understanding, Lordship, in that judgment, what happened? The court has not given finding. Whatever stand has taken, against that stand, Lordship, no finding was there. So here my case is different. Finding has been given. Whatever stand is now taken, that issue already resolved. So far my understanding, Lordship,
Okay.
that judgment will not
Proceed
applicable.
for respondent number 1, 2, and
I'm for 1, 2, and 3.
1, 2, and 3. Mr. Gogoi for respondent number 5. And Mr. Sarma for 4. Respondent number 4. Argument concluded. Order reserved.
Lordship.
Grateful.
Highly honest.
Highly honored.
Pending item 2.
Please. None appears for the petitioner on call. For the accused on call, list the matter after a week. In the event of subsequent non-representation, appropriate order shall follow. How about Mr. Bartakur, learned additional PP present?
Yes.
61.
Sixty-one.
Dear my lord, FIR has been lodged stating that during a recruitment process to the Assam Police Constable, the Assam Police in 2021, records of physical efficiency test have been manipulated, particularly the data about a running event, and shown some persons named in the FIR as passed, who actually didn't qualify. They were shown as qualified. So this would be clear if your lordship kindly see the FIR at page 27.
Okay, what is your instruction?
regarding the federal level.
Hmm?
Yes, but I have done this year record with. And my lord, regarding so only 2 witnesses now examined till now. State submitted against to tell my lord 18 numbers of accused persons. My lord, with a prayer that if it were
Supplementary charge sheet with sanction against some police personnel.
that my lord, that part is not available in the case. And my lord, from the record, from the content of the FIR itself, it reveals that my lord, regarding manipulation of records during physical efficiency tests, my lord.
No, that's all right. Is there any material against the present petition?
Material against the accused, that is the question.
The only 2 witnesses, my lord, evidence of 2 witnesses, my lord, is there in PROCEEDINGS. And regarding
Whether they have implicated him?
yes, my lord, regarding from their evidence, my lord, regarding the name of the present, my lord, petitioner, my lord, they have not stated anything about that, my lord, from the FIR, name of the 3 accused person here. I would like to point out.
In the FIR also, his name is not there.
FIR, her name is not there. my lord.
Okay.
She was selected and now.
No, she is not selected. In this process, in the recruitment process 2021, she has not been selected. She didn't qualify in the physical test. But in the next process, which is conducted in 2023, advertisement issued in 2023, and the process concluded in 2025. In that process, she has been qualified. She was selected and she was appointed, but she joined event. And after that, she was not allowed to go for the mandatory training on account of pendency of this case. This case relates to the earlier recruitment process initiated in 2021, and she has been selected in the recruitment process initiated in 2023, completely separate process.
So have you gone through the statement of the witnesses who are yet to be examined?
Yes.
But
yeah, up to that, my lord, records because otherwise.
No.
PW2, evidence of PW2 was taken only on my lord.
PW2 is here on the
In the month of May, 2026.
No, that's all right. Mr. Borthakur,
Yes, sir. I would like to point out only one aspect of the case because some technical evidence is also there. Your lordship may kindly come to page 33 of this circuit. Only one aspect I would like to point out here. Second paragraph, madam.
33.
Page 33 of this circuit, madam.
Hmm.
During investigation, the DLSC, District Level Selection Committee, inquired into the complaint and checked the CCTV footage corresponding to the event. And after comparing the timings from the footage with that in the results, mismatches were found. From preliminary analysis, it appears that in case of these candidates, the electronically generated PET results, physical efficiency test results, have been manipulated before putting up before the DLSC. Further, IO indicated the PO, complainant and witnesses were examined and recorded their statements under section 161 KPC, where the witnesses revealed that the apparently accused persons are involved in fraudulently giving job in the Department of Assam Police. Well, this is important. The CCTV footages were analyzed and the RFID data, regular frequency identification data, collected during the event and stored in the main backup server were compared, during which anomalies of the below arrested candidates were found. So CTR analysis of all the arrested candidates were analyzed and found linkage between them. Well, on not saying about the CTR analysis, madam. From the CCTV footage and RFID data collected, which those data were collected regarding some FSL report, some technical analysis, detailed analysis report is also there. I have that mark, but those technical analysis, details, it is difficult for me to ascertain, because on the basis of those technical analysis details, which were stored in the server, later on, during investigation found that those data were manipulated, and by manipulating those data,
No, that's all right.
My lord,
There
who
may be-
manipulated in whose favor? This is the question, my lord. The charge sheet, they don't say that the petitioner
got any benefit or her data was manipulated. Only the linkage, this CDR analysis of all the arrested persons were analyzed and found linkage between them.
My lord, friends, my lord, question of my lord, getting benefit will not arise well.
But there is a charge has been framed.
He participates in the, my lord, process, my lord.
So, and your lordship can see the all the statements, including the experts who examined these technical things, are recorded under section 161. And this statement nowhere mentions the petitioner and or indirectly alleges anything against her. I have annexed all the statements recorded under 161. And for attracting 420, it has to be shown that she got some benefit. The main accused were 9, my lord, in the FIR. 3 are the beneficiary, 3 are the engineers involved, and 3 are the fathers of the beneficiaries who are the personnel in the Assam Police.
Mr. Borthakur, so statement of some of the witnesses were recorded by the investigating officer. Have you gone through the statements?
161 statements, my lord, I have gone through some of the statements, my lord. From there, yes, nobody has taken the name of the present petitioner. There is no.
No whisper.
Because some of the technical data are available in the record, my lord. Because those technical experts, my lord, evidence of those technical experts, my lord, regarding they have not said regarding to what is there in those, my lord, technical records, my lord, data, my lord, regarding that, my lord, I have not found then, my lord, those, my lord, statements of the those technical experts.
No, so according to you, none of the witnesses examined under section 161 CRPC have implicated her.
Yes.
For direct implication against her,
No.
But only those, because those technical data were.
You do one thing, you obtain instruction from the investigating officer. Who was the investigating officer at that point of time? Who had investigated the case?
Yes. I will have to check now.
You say, can you obtain instruction of what was the material available against her for which she has been solicited in this matter? Because you have seen the statement of the witnesses.
Yes.
And also the evidence adduced before the court.
Yes.
None have implicated
Yes.
her.
Not.
Then under what circumstances the IO has a.
Because the entire those evidences were some technical because of the.
No, that's all right. Whether that technical evidence is collected or not.
Those
Her-
I have flag mark.
Her phone number has been found.
I have flag mark.
Her in the CDR of the other accused. Her
I'm not
phone
talking
number.
about, not saying about CDR, regarding those data which were there in at that point of time. So RFT that is referring that your frequency, identification data, and that is recorded CCTV. There regarding that one technical report, I have flag mark.
No, is there any implication against her?
That it is difficult for me to assert from those.
So then you obtain instruction from the IO. Or we keep this matter parted.
So in that case, your lordship may kindly consider the interim relief because the earlier order says that today it would be considered.
No, finally we will hear and dispose of the matter.
Otherwise, some deposition of those technical experts, after
Their statements are there in under 161.
then what is there in those technical details, if they can specifically state before the.
Okay, you obtain instruction from the IO then.
Can you
Pardon,
consider
sir.
the interim relief? My
Pardon?
lord, interim relief may kindly be considered only against her.
We'll
If there
finally
is no
hear and
material, your
dispose.
lordship can.
Finally hear and dispose of the matter. Heard Mr. Lockor, learned counsel for the.
All escort.
Whole Oscar learned counsel for the petitioner. And Mr. Borthakur learned additional PP for the state respondent. Heard in part. list the matter on next Tuesday
Yes, sir.
for further consideration.
No, Tuesday, because who was the, I was. And
Today is Monday. 8 days are there. Place the matter on next Tuesday for further consideration. In the meantime, Mr. Borthakur shall obtain instruction from the investigating officer as to under what circumstances the petitioner herein is charged. Yes. Indisputably, none of the witnesses examined under section 161 CRPC and also the witnesses examined before the learned trial court have implicated the present accused. The present petitioner, list accordingly. As part her.
Highly obliged.
We have given our press wakalatnama for filing today. We have received it from the newly implicated one.
So the newly implicated contender would like to file affidavit.
Yes, my lord, may I allow the newly implicated, then we will
No,
file.
or you want to implement the order.
We would like to file an affidavit, madam, because our stand is that we have complied with the decision. So lordship may give us a liberty to file a press affidavit.
Yes.
They are saying already that they have complied with the order. Probably that same stand will come in the new affidavit also. And Lordship has already heard the matter, what is their stand and whether this stand taken in the affidavit is Lordship shows that they have complied with the order. So Lordship, if they want to file the new implementation, let him file it within a 1 week, Lordship, and fix the matter.
Heard Mr. Coletta, learned counsel for the petitioner. And also heard Mr. Borthakur, learned counsel for the contender. Mr. Borthakur submits that he may be granted some time to file affidavit on behalf of the newly implicated contender. Pair allowed, list the matter for final consideration on.
No.
Sorted. Alternate. 21st. This is a list the matter on 21st.
As part of
Alternate.
I would like.
Now, earlier, in the morning I have moved, but public prosecutor wants some time.
Is it 60 days offense?
Already 73 days is in the jail, languishing in the jail.
I will pass the order then. Default bail.